You are Mr.
M. Hussain on behalf of A.J. Ahmed.
M. Hussain, appearing on behalf of Mr. H. Ahmed. And when also heard
Abdul B. Abbas.
Muhammad S. Jed B. Abbas, declared counsel for the petitioners, both in criminal petition number 470/2024 and 563 of 2023, paid by night with the consent of the other side.
My lord, there is an
Accordingly,
interim.
Prayer is allowed. Interim be continued. In your case, was there any interim? No.
Lordship.
Interim be continued till next date in respect of criminal petition number 563 of the
What cases, my lord, interim?
Interim is there, Lord.
both these cases.
Yes, Lord.
Set it on both the cases. Criminal interim be continued till next date of the criminal petitions.
After vacation, my lord.
22nd of July.
Deeply obliged.
Wait, this is lordship. I beg to mention item number 41 with the consent of the petitioner, Your Honor.
41.
41. Lordship may pass over a matter of 43, Lordship.
Passable matter
For the day.
for the day.
For the date. Interim is there, Your Honor.
You are MS.
B does respond number 2.
So you are B dash respond number 2. But have you informed the other side?
I am
Yes.
for the petitioner, Your Honor.
You are for the petition. Was there any interim?
There is the interim order. That may be
With the
continued.
consent of the other side. MS B does it and it comes to which and it comes to for the petition is not matter be adjourned for the day and will be listed accordingly as on a date to be fixed by the registry. Interim be continued till next date.
Lordship, due consent with other side, Lordship. I beg to mention item number 42, Lordship. Lordship, may the matter
40?
adjourn for the day. Item 42, Lordship.
Madam, I am
42.
for the appellant in this matter, my lord. So
You are for the appellate.
yes, my lord. My only prayer, my lord, on 21st, 23rd of July after vacation, my lord. It is against equity law under 376 and POCSO Act, my lord. We are against
Oh.
equity. We are informant.
Achha.
So, my lord.
They appeal against acquittal. Heard Mr. P.K. Tekar, it and counsel for the appellant, and also heard you are Mr.
A.R. Mondal. Respondent number 2, Lordship.
A.R. Mondal, a respondent number 2, and also heard Mr. S.H. Bora, regarding additional period being on the Mr. Mondal, regarding counsel for the respondent, paid for an adjournment to stating some inconvenience on their part. To which Mr. Dekar, regarding counsel for the appellant. List matter accordingly. Either 21 or 23rd, you are saying?
Either of these 2 days.
23rd. Okay.
Marks of life.
Your
Lordship, I beg to mention item number 16, Your Honor.
Item number
16,
16.
yes. Your Honor, the matter may be taken up after the vacation, Your Honor. As my senior counsel is facing some difficulties, Your Honor.
With the senior counsel,
As Kanungoy.
S. Kanango.
Yeah, as Kanungoy.
And have you informed the other side?
Yes, Your Honor. We have informed the opposite side.
16 Nico with the consent of the other side, and counsel appearing on behalf of MSS Kanungo for the appellant, paid for an adjournment. Prayer account, date the matter be accordingly listed. You want any fixed date or after vacation?
The vacation, Your Lordship.
Yeah, obviously after vacation. Want any fixed date or after
Any
vacation?
date, Your
After vacation as on a date to be fixed by the ministry.
May I please, Your Lordship? Lordship, I beg to mention item number 13. I am appearing for respondent number 2, 3, and 4. Item number 13. I am taking consent, Lordship, other side, from the other side.
You are appearing for the respond number 2, 3, and 4.
2, 3, and 4. Matter may be adjourned.
So you are for the respondent.
Yes, Lordship.
Have you informed the other side, the appellant
Yes,
side?
Lordship.
With the consent of the other side. Then it counts. Appearing for the respondent number 2, 3, and 4. You are MS? What your name?
R. Kha.
appearing appearing on behalf of Mr. M. Hussain for the response number 2, 3, and 4. Wait for an adjournment. Prayer around. Please demand. You want any fixed date here?
3 weeks.
After 3 weeks? After vacation? After vacation, as on a date to be fixed.
Obliged.
Lordship, I beg to mention item number 23.
23. Yes.
Lordship, today we have some difficulty. The matter may be fixed anytime next week.
We have received this scan copy here.
Yes, sir.
Next week, Parikoda. Better not to give. Better not to give you. Is there any interim? No.
No, Lord. Then after a week, it may be listed.
Okay, then after a week. Had Mr. A. Mishra, the learning council body, submitted that due to some inconvenience on the part of the NGS council. Paid by nature. It is submitted by Ms. Bora that the learning additional BP that scan copy of the TCR has already been received. Please the matter accordingly after a week as an date.
May I please, your lordship, with the consent of other side, I beg to mention item number 37, man. Kindly adjourn the matter for the day, man.
Your Honor, I am for the respondent in this case.
You are for the respondent.
37 and 38 are connected matters, Your Honor.
Pardon? Connected?
37 and 38 are connected matters.
Oh,
I am for the respondent. I am appearing on behalf of Mr. A. Tiwari.
in both the matters, you are for the respondent.
Yes, Your Honor. In 769, I am for respondent 2, 3, and 4, and in 304, I am for respondent 2.
37 and 38 connected. Criminal appeal or criminal petition. You are Mr.
S. Ahmed, on behalf of PK Rojo.
S. Ahmed. Heard Mr. S. Ahmed appearing on behalf of Mr. PK Roy Chaudhary. PK Roy Chaudhary for the not so hard. You are MS
O. Gupta.
O. Gupta appearing on behalf of Mr. A. Tiwari for the respondents. Is submitted by Mr. So and so appearing on behalf of Mr. P.K. Roy Chaudhary that due to some personal inconvenience, he is not in a position to argue the matter today. And the council appearing for the learned council appearing for the respondent also raised list the matter when after vacation.
After vacation, any date.
Date you want?
Yes.
You want date?
No, my lord, any date, after vacation.
No, you want a fixed date. That's what I'm saying. You want a fixed date?
No.
After vacation will do?
Oh.
Okay. After vacation as on a date we fix.
Obliged.
That is
Yes.
Lordship, item number 6, my lord. I may be allowed to withdraw this, please.
Item number 6. It was a BA.
BL.
Heard Mr. T. Google, the learned counsel for the petition. Heard MSSH for the learned petition will be appearing on state respondent. Submitted that as per instructions of the petition, he wants to withdraw. To which MS border is no according to prayer and matter is disposed of.
Lordship, deeply moved.
May it please your lordship.
Yes.
My lord, this is a 483 bail application. My lord, petitioner was arrested on 18/6/2026. Till date he is in jail. Matter of 28 days in jail. That
18/6.
18/6/26. Today 28 days. Oh, 18/5. Sorry.
Oh, 18/5.
18/5.
That's what I'm. Why
6 is yet to come.
Achha, he is in 28 days in jail.
He is in
28
jail.
days in jail.
Gentlemen.
Under which section? Cases?
Under section, my lord, 3032, 61(2), 35, and reduced section 31, Assam Cattle and Prevention Act 21. And my lord, FIR is page 14, relevant page is 18, my lord. May I read this FIR, my lord? With due respect, I have honor to report that on 17/5/26, during inquiry conducted in connected with the information received regarding suspicious movement of vehicle in the areas Ukanguri, Hilika, Makum, and adjoining localities, it came to light from the reliable source Then an organization cattle theft and smuggling rackets has been operating in Tinsukia district and nearby areas. During the course of inquiry, it was revealed that one magic vehicle bearing registration number so and so and one black color Alto vehicle without registration number were allegedly being used for illegal transportation of stolen cattle. It was further found that the Alto vehicle has been specifically modified by removing its seat for the purpose of the secretly transporting cattle illegally. Accordingly, on 17/5/2026, in the early morning hours, local people of Pukanguri T intercept and detained the aforesaid vehicle near Bapajan while they were allegedly transporting stolen cattle illegally. My lord, these two paragraphs very important, my lord. The local people stated that magic vehicle bearing registration number so and so was carrying two cows tied in a very cruel manner with a ropes, while the black color Alto vehicle was carrying another two cows inside the vehicle. The local people immediately rescued the cattle from the vehicle. Thereafter, a large crowd of 300 people gathered at the spot, resulting in a serious law and order situation during the some miscreants set the vehicle on fire. Taking advantage of the commotion and chaos created at the spot, the rescued cattle escaped from the place and could not be secured thereafter. My lord, is it possible from 300 people rescued cattle played with? Can it be possible, my lord? And the petitioner, before your lordship, he is owner of the vehicle, my lord, Tata Magic, and there is, as per the FIR, my lord, two vehicles involved. They are seized. Can you kindly see the annexure 3? Page 22, Caesar list 24. That last page of the bail application, my lord. One four-wheeler is banned condition bearing registration number A23DC 7110 Maruti Suzuki, my lord. Where is the Alto, my lord? Why they are not seized the vehicle, my lord? This completely a false story making out against the petitioner. My lord, can you come to the FIR again, my lord? Where the how this petitioner was arrested, my lord? Actually, the petitioner was is the owner of the said vehicle and he is giving that vehicle to one three Jog Bahadur Sharma. That is I have mentioned in paragraph 6 of my bail application, my lord. As a rented base per day 2,000 rupees as a rented basis. And that's Jog Bahadur Sharma without informing the petitioner. He gave that vehicle one three Godadhar Gohai. He is given that vehicle to Godadhar. He is the main culprit, my lord. At the time of rescuing the cattle, neither the petitioner was present in the on the spot, nor he is driving. He is the owner of the vehicle, my lord. After knowing knowing from the Jog Bahadur Sharma that
Is
his
he owner
vehicle,
of Magic or Alto?
he is the owner of the magic, my lord. And he is given that magic to Jog Bahadur Sharma, my lord. And he is informed that his vehicle was theft. And accordingly, he came to the Makum police station and he gave an FIR. But that FIR is not registered. Makum police station hand over this petition to the Dumduma police station. And he has been arrested on 18/5/2026. But till that this is a totally a making case, my lord. And this FIR itself shows there is no prima facie made in any cattle smuggling or transportation or whatever it may be, madam. So last 20 days, this person is in jail without committing any crime. And the police have failed to search that main Bagadhar Gohai, the main culprit. So if cattle in the vehicle, how cattle is escaped from the 300 people? My lord, this is, my lord, I can't digest. And that too, all the kettles are tied by rope, my lord. That is itself is shown in the FIR, my lord. and one vehicle was seized, another was not seized. And no kettle was found in possession of the petitioner, my lord. How can it be responsible for that? If somebody else doing crime to taking advantage of the vehicle, my lord. And that way a third party on.
The last part of FIR,
Lordship,
that is the main gate.
yes, Lordship, kindly come to page 20, and it's the last two paragraphs, Lordship.
Yes.
As a Lordship got it, may I read, Lordship? The preliminary inquiry further disclosed that the accused persons, along with their associates, were allegedly involved in organized theft of cattle from different villages of Tinsukia district and adjoining area and transportation of such cattle for illegal slaughter and sale of meat. It was also transpired during inquiry that although the said vehicle has already been detained by local people during the early morning hours of 17/5/2026. Subsequently, one of the accused persons, namely Bablu Mahatu, the present petitioner, has appeared before the Makum police station at about 11 a.m. on the same day and lodged a false FIR alleging theft of the magic vehicle from Makum area during the midnight hours of so and so. Apparently, with the intention to mislead the police investigation and conceal involvement in illegal cattle smuggling activities. So, Lordship, because after the local people intercepted the vehicles, the owner of
That he
the
lost an
thereafter he has chosen a that it has been stolen by somebody else. So, to that regard, only Lordship, I need the CD. CD will reveal the
it is not
complicity
a
of the
case
present
of as what Mr. Das is submitted. It is not a case so easy.
Lordship.
No, my lord,
It
in
was a
this case, what
that
happened, my
he
lord?
lost the FIR intentionally. As
Yes.
per the FIR and as per the reporting. I'm not the
Yes,
actual
Lordship.
fact.
So,
Maybe
Nothing was
maybe-
found in, because I have bound to file the FIR
Because-
because the vehicle is in my name, my lord.
But on the same night only you have FIR.
Not
Yes.
same night, my lord.
Why?
On the same
Why-
day,
My lord, on same day that Sharma informed me that vehicle was theft. Then only I came
Vehicle
to
was?
Huh?
Vehicle was? What?
vehicle was theft from the bazaar. That Sharma, whom I am giving that vehicle to
Okay,
in a
within
rent.
this city.
city is
So that is that only I came to know that because of my vehicle is theft, I have to give FIR. Otherwise, I am not getting the insurance and other.
But
But-
what preliminary investigation says that it is the intentionally you lost the FIR with the intention to only to
This
mislead
is
because
the
this
police
is
investigation.
she kept all the
yes,
by-
my lord. This is the case, my lord. Why police? How police know this is intentionally? No cattle was found in my possession.
It's an
Neither
organized
I am
crime,
not
Lord.
driving. I am not present
No,
in
no,
that.
you want to drive.
And nobody-
admittedly,
that-
there is
Admittedly, you are
no
not-
such
I am not
allegations
present
against you.
also. I am
Nothing was
just linked
recovered
with the
from him
vehicle
also.
because this
That is
vehicle
not the
is
issue,
mine.
Lordship. That is
That
not the
is-
issue.
Pardon?
That the cows has been recovered from his possession.
That is
not
the issue, my lord. How can they prove that case that
Because
whether
he
this
owns
is
the
cattle
truck.
or not?
Owner of the Mazik, Lordship.
Yes.
So where the cattle was found, my lord?
So let us
So if
give
they are
us the-
saying that in my major cattle was found, then
I
where is the
cannot say.
cattle, my lord?
It has to come from Tinsukia, no?
Tinsukia, Lordship.
Mr. Purua. Will it be able to priority? Oh. No problem. You know,
26 minute time to go forward.
তাকে চেষ্টা করো।
No, let's go to
That's-
Yes. That's probably. Okay, na matna fix kori. Why na kare? I just talked to him. There are many matters have already been fixed, and next week will be declared as the motion day. Motion week.
Lordship, probably.
Somehow, but still, because he is in custody,
He is
so
in custody, my
we are listing it on 25/6.
25/6. March.
Obliged.
City Court.
Yeah, please. So this is my charge sheeted POCSO case.
Oh,
So this is case melot, TCR may be called for. This is from Chief Sagar melot, and notice may be issued to the inform melot.
Part Mr. Kigogo, the Ghanaian Council of the petition of that means SH for the Ghanaian petition, should respondent issue notice to the respondent number 2 to speed post and to speed post and the usual process. No, to jurisdictional police station routed to the office of the registry and the public prosecutor. Also call for the scan PCR. Registry will do it. Yes, when it can. After vacation, 17 will do.
Lodge.
17.
Highly obliged.
Yes.
My lord, regular bail application, my lord.
Yes.
It's a POCSO case, my lord. FIR may be seen at page 10. Uh, 26 days behind the bar, my lord.
How many days?
26 days.
But POCSO, we don't have any alternative. We have to issue
My
notice.
lord, then before vacation, any day,
Before
26
vacation,
also maybe.
I don't think your supper purpose will be served.
My lord, 26 last day of
26 we are
before
not
vacation.
fixing any. There are some reasons.
Let us try, my lord. It's from Nunmati, my lord,
Try
this is
we can
Gauhati,
try, na? You are Mr. Ali?
my lord.
Hi, Mr. M. Ali, the London petition. Issue notice to the respondent number 2 to jurisdictional police station, deputy office of the registry and the public prosecutor. Also call for the CD. 25/6.
Highly obliged.
Make yes,
Yes.
yes. 483 application, you know, POSCO is there. So at this stage, notice may go, you know, along with case diary.
Same order. Yeah, listing it before vacation, but
Sangsari, you know,
Huh?
Sangsari.
no, Sangsar is not the question for us only. We are not in a position to accommodate all the matters before vacation.
Already,
Sangsar is all right.
already
understand, Sangsar.
29 days,
How many days?
29 days, you know.
25, 24/6.
Okay. Deeply obliged, you know.
Sorry, petition no more. Okay. Good. Good. Some case, getting to pull up. And I know. Little like you order to or 19 of the hearing. It's supposed to come here. It's come for by 19 on Atari. It's
Please, your lordship.
yes, fine. Yes.
41 days behind the bar, lordship. Case diary will be required. We call for before the vacation, lordship. Why I'm pressing because lordship, on page number 25, the present petitioner is fractured by both the legs, lordship, and he is in judicial custody since 41 days, lordship. On page number 25, lordship will find it, lordship.
25.
25, lordship. On third para, lordship.
Achha.
He is unable to move. He is unable to do anything, lordship. last day of before vacation.
How he got fracture?
Before he was arrested. In this case, he was shown arrested, Lordship. Before he was arrested in Panbazar PS case, Lordship. While he was arrested, he was manhandled by the public, Lordship.
Oh. And then only in Nunmati he was shown arrest.
Thereafter, again Panbazar have shown arrest in a different case. Thereafter, Nunmati has shown arrest. Other cases are fixed tomorrow. Panbazar case.
For Panbazar. Panbazar, what are the section here to 3042 and 112?
Yes.
And where the in Panbazar?
Same section.
Same section. He expert.
Three zero four is snatching, Lordship.
304 is snatching.
Yes, and 112 is petty organized crime. Subsection 2, whoever commits any petty organized crime shall be punished with imprisonment for a term which shall not be less than 1 year, but which may extend to 7 years.
And 304?
Snatching, Lordship.
Snatching,
No, snatching, what is the term?
Term is, Lordship,
7 years.
3 years, Lordship.
up to 3 years.
Which may up to extend to 3 years.
May extend to?
3 years.
The person hails from which? No, he is from West Bengal, na?
He is from West Bengal.
Yes, Lord.
Oh,
He's hailing from another district.
and the maximum this change nature or whatever, they
Yes.
are maximum hails from West Bengal.
West Bengal, snatchers.
Maximum snatcher.
Snatchers, yes.
Whenever we have come across this kind of cases, maximum from there.
Yes.
There's a racket in there. Whatever, we'll try to call for CDB call for query. Again, 24 DD, 24 6.
Deeply.
I
Yes.
please your lordship. This 42 BNSS application lordship.
Yes.
Two petitioner before your lordship. The FIR lordship will find at page number 8 lordship.
8.
8. The gist of the FIR is that lordships, the source information was received by the Gauhati police station lordship regarding illegal transportation of cattle lordship. And what happened, they have intercepted 2 vehicles lordship along with 62 numbers of cattle lordship. And while the police has asked to produce the documents lordship, the driver and handyman failed to produce the documents. Accordingly, the vehicle and cattle has been seized lordship and the FIR has been registered lordship. Now, there are 2 petitioners before lordship. Petitioner number 1 is the cattle owner lordship. I have annexed the cattle purchase receipt lordship at page number 15 to 52 lordship. Page number 15 to 52 lordship, kindly see. The cattle purchase receipt lordship, they have purchased the said cattle from Dolgaon Shalmari Development Block in the BTC. The co-party weekly cow and buffalo goat etc. market lordship. All the cattle purchase receipt lordships, the 40 numbers of cattle owned by the petition number 1 lordships, and he has also issued a veterinary fitness certificate at page number 53 lordship, issued by the veterinary officer lordship. Last page lordship. Last page lordship, page number 53 is a veterinary certificate issued by the veterinary officer lordships, issued on lordships and on same day lordships. Now, page number
Same day means?
on the day they have purchased the said cattle from the said market lordships. Then this
Why so many money receipts?
lordships.
They have purchased
Lots of-
cattle from the same market.
Same market law, same market.
So why many receipts are there?
Lots of the is a cattle market law. Is established under the
No, I can understand. It's
Lots of-
okay. He purchased from the cattle market.
yes.
I'm asking why many receipts are there?
No, the seller is the not a one person lordship. There's different person. They carry the cattle to the market lordships, and this petitioner lordship he purchased the said cattle from
But on same day,
on same day lordship.
same day.
But
And veterinary doctor have given these the certificate on for 40 numbers of male
lordship.
bull.
Veterinary have issued on regard that the cattle is sound for the transportation of.
Hmm.
The veterinary have
He's they are medically fit.
medically fit to transport the cattle lordship. And lordship your lordship well aware that lordship the Assam Cattle Preservation itself allows to transport cattle subject to the provision that lordships that the cattle have to purchase from the registered market lordship. The itself mentioned My humble submission before lordship, let them appear before the IOG documents lordship.
One is cattle owner, number two is
Number two is the vehicle owner lordship. I have annex the vehicle registration certificate at page number lordships. Page number 14 lordship.
ইমান গৰু কিনি কলৈ গেল ইমান গৰু কিনি কলৈ গেল why they purchase so many cows 40 50 number what to do
No lordship
number four I'm just not academically just I'm asking why they purchase 40 50
lordship
number of
they
cows?
purchase the cattle from the low price and they sell the cattle for high price lordship. That is
Where
the
in the market area
in the market lordship. In the market itself, they have carried the said cattle from the
For selling
property market to the
or
Sunapur,
for
Nagaon
transportation?
lordship.
For selling purpose only or
For selling
to transport the other states
For selling purpose only. Selling purpose only lordship.
and where from it goes to Bangladesh?
No, Bangladesh lordship is a different part. The police station is there lordship. The cattle has been intercepted in the Goshuk lordship. If they are going to the Meghalaya lordship, then the Bohista police station is there, Jurabat police station is there, Sunapur police station is there lordship. It's a different part. They have intercepted in the Goshuk lordship. And the lordship is well awarded lordship. The Assam Cattle Preservation also says that no permit is required to transport cattle one district to another lordship. No permission is required if the cattle is purchased from the registered market. Section 7, subsection 6, clause 2 specifically says lordship.
Other states.
If it is lordship, the subject of the provision, the cattle have to the cattle cannot transport to those districts lordship where the international border is transport sharing lordship. Like Karimganj, Dhuburi lordship, the exception is there lordship. Now our cattle was
To
purchased-
Meghalaya.
Meghalaya
can
lordship.
be.
Meghalaya, our cattle preservation act says that lordship, permission is required to transport cattle those districts where the international border is sharing.
No, for the other states.
Other state,
Other state laws also require permission laws or I say so. But the some cattle preservation act says that lordship. You lordship may kindly see section 7, section 6.
I know you are.
Lordship.
You did with-
My submission is that lordship, let them appear before the IOG documents lordship. If there is any discrimination found, your lordship may reject my prayer lordship. This is my humble submission lordship.
no, lordship, it was cattle were transported from Gorshuk, intercepted in Gorshuk. It was supposed to be transported to Meghalaya. From Meghalaya, there is a
It is allegation.
international border. Lordship is already aware of that.
If that
So-
line is not
If it is
enacted lordship, if that
possible
line is not added in the FIR lordship, then no section is added. Lordship, cruelty lordship also awarded that 50 rupees is fine only lordship. Cruelty so far cruelty is concerned lordship, 50 rupees fine. If that line is not added by the police lordship, your lordship will find any FIR. The police added said and that cattle was transferred to Meghalaya.
Meghalaya is a
That line is
different
common lordship.
state.
The state of affair lordship, your lordship will find in each and every affair lordship that deadline is added. Because to attack the Assam cattle preservation. And lordship, the vested interest is there lordship. Police lordship, they have after seizing the cattle to keep the Gusala lordship. Now lordship, the petitioner one is claiming lordship 14 numbers of cattle. One day they have to pay lordship, as a maintenance 500 rupees. Per day he is paying rupees 20,000
Yes, yes.
20,000 he is paying lordship.
Quite a good amount is to be.
Yes, lordship. Yes, that is the intention. That is the vested interest lordship. If the delay lordship, then cattle, if 1 month is crossed lordship, then the petitioner is unable to return back his cattle lordship. Because what Heman he has explained passing the said cattle, it is a higher to the giving the maintenance of Gusala lordship. That is the problem lordship.
Hard Mr. T. Sutia, learned counsel for the petition, and also hard Mr. State Court. The learned additional PPA, state responsibilities and application, section Swenson. It's submitted by Mr. Sutia that the accused petitioner number 1 is the owner of the cattle which have been seized in connection with this case. And accused petitioner number 2 is the vehicle owner. Registered vehicle owner of the vehicle from which the cattle are being seized by police. If it is submitted that the 40 numbers of the cattle which were being seized by police were purchased by the petitioner from the registered market of cattle, that is from which market?
The Koopati weekly cow buffalo goat market lordship. Koopati. Page number 15.
Gauhati.
Koopati. K-O-U.
Gauhati weekly
Cattle market lordship.
cattle market, which is the registered cattle market. And to that regard, he has also produced the money receipts along with the petition. Apart from that, he submitted that the cattle were being transported after the certificate issued by the veterinary doctor stating that they are physically fit for transportation. But at the time of the interception, the driver and the handyman could not produce all this document, hence they got arrested. And the petitioner number 1 as well as petitioner and the petitioner number 2 are searched by police, and hence they have the apprehension of arrest in connection with this case,
Within the state.
and hence
Within the-
proceed with this
Within the
case
state.
post. However, they are ready and willing to extend their cooperation in the investigation of this case if they are provided with some information. MS Bora, next one. MS Bora, the learned additional PP raised objection and submitted that from the FI itself, it is seen that the cows were carrying in the vehicle only with the purpose of transporting them to other states, that is in Meghalaya. When the police intercepted the vehicle and seized the cab. So accordingly, she submitted that the case diary will be recorded, and accordingly, she insisted to call for the case. Expert considering the submission made by the counsel for both sides. The annexures filed along with the petition. And other aspects of the case, this court is of opinion that some interim protection may be provided to both the petitioners who claim themselves to be the owner of the cattle as well as the vehicle respectively. Okay, you will be under interim protection.
That's it.
You will be under interim protection.
Lordship, I'm obliged, Lordship.
Lordship,
Obliged.
objection may be recorded because such as section 7 of Cattle Preservation Act, Lordship, it is clearly stated, prohibition of transport of cattle. No person shall transport or offer for transport or cause to be transported any cattle without any valid permission from any place of other state through Assam to any place outside the state of Assam.
But
My learned friend has stated that it is come under subsection 3, that is not applicable in the present case. Subsection 3 of 7 says, no person shall transport or offer for transport or cause to be transported any cattle from any place within the state of Assam to any other place in a district within the state which shares international border. That means, for example, you can say from
exception,
Hooghly.
Lordship. I put in the exception, Lordship.
That is not applicable in the case because it has been transported to another state and without any valid
Yes, that's
document.
what I'm asking,
He has
recording your
failed to-
submission
He has
that,
been failed to give the valid documents.
yes,
My
for
objection
transportation.
is-
Yes, that has been recorded. That is, they are going to, with a view to transport them to Meghalaya, the state of Meghalaya.
Yes.
I'm obliged, Lordship.
Well, it can, 17th of July.
Obliged, Lordship.
May I
Yes.
please, Your Lordship? Herein, Your Lordship, in the year of 2024, this affair was lost by the President of Rashtriya Bajrang Dal, Your Lordship. And herein the allegation of rape has been made against the present petitioner and one Habizul Khan. And after completion of investigation, charge sheet was submitted against 2 persons who were arrested in connection with this case. And in the charge sheet, the name of the present petitioner has been shown as accused not sent up for trial, Your Lordship.
In charge sheet.
Yes. And thereafter cognizance was taken against the person who were arrested in connection with this case. Now, Your Lordship, kindly have a look at page 28, Your Lordship, kindly see. In
Yes.
and relevant parties at page 30, Your Lordship. Para 2.
Page 30.
Yes, page 30, para number 2. Herein the learned court below has been held that the investigation of the case was not properly done, and accordingly it was held that without having additional investigation, continuation of trial would be miscarriage of justice, Your Lordship. And accordingly, it was ordered for further investigation of this case, Your Lordship. I'm reading paragraph number 2, Your Lordship, page 30. Therefore, after going over the pertinent laws
examining the charge sheet and other materials presented to the court, and noting how the charge sheet was submitted in this particular case, while keeping in mind the Honorable Apex Court observation in the aforementioned referred judgments, I believe that a trial without additional investigation in this case would be a miscarriage of justice because of IO's lackluster approach and the charge sheet's mechanical presentation. In result, I not only order further investigation in this matter, but also direct that this matter be brought to the attention of ACP Swanso so that he can supervise the investigation in this case. Have it investigated by a competent officer and take the necessary action to check such a lackluster investigation, keeping in mind the type of investigation that has been conducted in the case pertaining to the offenses against children, which are considered the most heinous offense, Your Lord. And during the course of investigation, Your Lordship, no attempt was made to interrogate the present petitioner, Your Lordship. And therefore, Your Lordship, I am apprehending arrest, Your Lordship.
I mean, why? How you connect yourself with the case?
Because in the FIR, my name is there, Your Lordship.
Your name was there.
Yes. My name was mentioned in the FIR.
Where is the FIR?
FIR is at page 19, Your Lordship. 19, eh? At page 19, Your Lordship.
Yes, yes.
Here in the allegation,
What is your name?
Rup Khan, Your Lordship.
Oh. Yes. Very nice or very, I mean, the order is very plain, very nicely. Very good order has been passed. Now see the conduct of the investigating officer.
Lordship.
Such a allegation is there. Such a nasty allegation is there. And that apart, he filed the charge sheet without being implicated this petition.
Lordship.
Rup Khan.
There was
See.
specific allegation in the FIR.
Yes,
against
yes.
a
It is the petition. It is outrightly can be rejected, your petition.
Yes.
Not even necessary to call for the case diary.
Yes, Lordship. At this
The investigation is required.
Yes.
Investigation is very essential.
Yes, Lordship.
Against you, all the allegations against you that you raped the girl for 2 days
Yes.
there. And
Yes.
now we are saying that you are not at all involved. Now see how the police officer is conducting. That's why this good order is passed. And it was passed the order
Yes.
that
Lordship.
has to be investigated in the with the supervision of the ACP crime. Very good order.
Lordship, page 30.
Yes, page 30.
No. Page
It should be
32.
rejected.
Page 32, Your Lordship.
Just
Kindly.
everybody scan copy.
Scan copy, yes.
But what I'm submitting, Your Lordship, page 32.
Issue notice to the respondent number 2 to the additional police station routed to the office of the registry and the public prosecutor. Also call for the scan TCR along with the case diary. Registry will do the needful. Let the matter be accordingly listed. After vacation, any date? 2 20. What you do otherwise? You seems to be very powerful. What you do?
He's a mechanic.
Can. Simple mechanic.
But
very powerful.
Seems
to be very powerful.
No.
He managed the entire
The
investigating
fact is that,
machinery.
Your Lordship, she had a relation with one Sandeep Kumar Shah, Your Lordship.
No, he had managed
And
the
that-
entire investigation.
Yes, yes.
Very powerful. Seems to be very powerful.
But the
Though
fact,
maybe he a mechanic, I
Yes.
don't know.
but the fact is that, Your Lordship, the Sandeep Kumar Shah left the victim, Your Lordship,
Thereafter, they have committed rape on
And
the
that's
two
what
persons,
it is.
Lordship.
and Annexer 5, Your Lordship, the Elise victim girl, she also lost an FIR, Your Lordship. That is at page 32
Against whom? Against Sunny.
against the present petitioner regarding kidnapping of Sunny, Your Lordship. And in that,
Sunny was missing, na?
no, Sunny, he
As per
left,
FIR, that Sunny was missing
He
and
went to Bihar,
his
Your Lordship.
mobile was also switch off.
Yes.
In a switch off mode. His mobile.
he is presently residing along with his father, Your Lordship, in Bihar, Your Lordship.
Presently is okay, but at that
And the
during that
address
period
of-
Time at
incident,
11 point
An
of time,
address
you-
of Sunny Kumar
fled
Shah was given to the police, Your Lordship, in subsequent case which was lost by the Ellis victim girl, Your Lordship. And in connection with that case, the present petitioner, he was arrested. And thereafter, he was released on bail.
that is a kidnapping matter. It's okay. Because she lost the FIR as because he was not there and his mobile was also switched off. She could not find him. And keeping there when she was there in the house, then only your petitioner committed such kind of offense for 2 days only.
On the same allegation, Your Lordship, in the subsequent FIR, Your Lordship, there is no any whisper
No, the
committing
next
rape, Your Lordship.
maybe.
And that was lost by the victim herself, Your Lordship.
Okay. Okay, we are listing it on 27.
Yes. Notice, Your Lordship.
Yes, notice you have to issue.
Obliged.
May I please, Lordship? This is a petitioner number 1 is the senior citizen and petitioner number 2 is the minor. Lordship, page
Minor.
number,
Over
page
there
nu-
here.
my lord, page number 12, 13 is the
Would be
birth certificate. My lord, FIR is page number 20. Is the party. Particular, Lordship, may I read, Lordship? Page number 20, Lordship. Ezaher, Asamir Nam, Amjad Ali, petitioner number 1 and 2 has, sorry, petitioner number 2 is the Amjad Ali and petitioner number 1 is the Hasim Ali. এজাহারকারী সম্মানপূর্বক বিনীত নিবেদন এই যে এজাহারকারী উল্লেখিত ঠিকনাৰ বাসিন্দা স্থায়ী বাসিন্দা হয় উল্লেখ কৰা 1 নং আসামীৰ লগত এজাহাৰকাৰী ছোৱালী ৰহিমা খাতুন বয়স 17 বছৰ পৰচনামূলকভাৱে প্ৰেমৰ সম্পৰ্ক গঢ়ি তোলে বহুত প্ৰতাৰণামূলকভাৱে বিয়াৰ প্ৰলোভন দি এজাহাৰকাৰী ছোৱালীৰ লগত যৌন সম্পৰ্ক কৰে আৰু জোৰ জবৰদস্তি গোপন ফটো ভিডিঅ' কৰে 2 নং আসামীয়ে 1 নং আসামীৰ বিয়াৰ বাবে প্ৰস্তাৱ প্ৰদান কৰে কিন্তু এজাহাৰকাৰী উপযুক্ত বয়স নোহোৱাৰ বাবে উক্ত প্ৰস্তাৱ প্ৰত্যাখ্যান কৰে 1 নং আসামীয়ে কেইবাবাৰো এজাহাৰকাৰী ছোৱালীক পলুৱাই নিবলৈ প্ৰস্তাৱ দিয়ে কিন্তু এজাহাৰকাৰী ছোৱালী পলাই যাবলৈ অমান্তি হোৱাত 1 নং আসামীয়ে এজাহাৰকাৰী ছোৱালীক ব্লেকমেইলিং কৰিবলৈ আৰম্ভ কৰে যাৰ ফলস্বৰূপে 1 নং আসামীৰ লগত যিমান গোপন ফটো ভিডিঅ' আছিল সেই সকলোবোৰ সামাজিক মাধ্যম যোগে প্ৰচাৰ কৰি দিয়ে আজি 15 দিন ধৰি সোয়েনশো নামৰ ইনষ্টাগ্ৰাম ফেক একাউণ্টৰ যোগে এজাহাৰকাৰী ছোৱালীৰ নগ্ন ফটোৰ লগতে কিছু অশালীন ভিডিঅ' উক্ত একাউণ্টৰ যোগে প্ৰচাৰ কৰি থকা গৈছে এজাহাৰকাৰী পৰিয়ালৰ লোকে 1 নং আসামীক বহুত অনুৰোধ কৰাৰ পিছতো সামাজিক মাধ্যম যোগে প্ৰচাৰ কৰি আছে আৰু হুমকি প্ৰদান কৰি আছে এজাহাৰকাৰী ছোৱালীজনী চৰিত্ৰহীন ছোৱালী বুলি সামাজিক মাধ্যম যোগে প্ৰচাৰ কৰি আছে আৰু 1 নং আসামীক ধমকি প্ৰদান কৰিছে 1 নং এজাহাৰকাৰী ছোৱালীজনীক ৰাস্তা ঘাটত য'তেই পাই মূৰত এচিড ঢালি জীৱন ধ্বংস কৰি দিব নহ'লে আসক্ত ল'ৰাবোৰক ভাড়াতে এজাহাৰকাৰী আৰু এজাহাৰকাৰী ছোৱালীক প্ৰাণে হত্যা কৰি ব্ৰহ্মপুত্ৰ নদীত উটুৱাই দিব ইয়াৰ উপৰিও বৰ্তমান অৱস্থাত 1 নং আসামীয়ে কিছুমান গুণ্ডা বাহিনীৰ দাগ আসক্ত কিছু অচিনাকি মানুহ এজাহাৰকাৰী ঘৰৰ চাৰিওফালে সময়ে সময়ে দেখা পায় আৰু ফোন যোগে আছে দিছ ইজ দ্য এলিগেশ্যন মাই লৰ্ড already I have stated in my paragraph number 6 that till date the petitioner number 2 has not personally meet the petition victim card and Instagram account mentioned in there is not my account and there is nothing allegations against the petitioner number 1, my lord. Only one is allegations he given proposal for marriage. And petition number 2 is the minor. And petition number is the name accused person, and he is the citizen, senior citizen lordship. And nothing against allegations against the petitioner number 1. All are petition number 2, but he has not. There is specifically statements in my petition that he personally did not meet the victim girl lordship.
Who personally did not meet the victim?
Victim girl and petition number 2.
Never personally meet.
They did not meet personally. Did not meet it. Already I stated in my petition, my lord, paragraph number 6.
But how this?
But already there is a love affairs, but overall they are carried on their love affairs. Actually, they did not. Petitioner number 2. Petitioners are residing in Borpeta, and victim girl is residing in Sonapur. There is a vast difference. Both are minors.
Yes.
Lordship, since petitioner number 2 before Lordships is the prime accused, who happens to be the minor accused. So he has to be AB, whether AB is the required Lordship, AB is maintainable or not.
Many views. I also
Many
think
views,
that,
yes.
yes.
It is not yet decided by the
Otherwise,
Supreme Court, yes.
if he is a suppose minor or juvenile,
His
that
bail
in that
application
case-
may be considered by the special forum, that is SAB. And so far as
Special
petitioner
forum-
number 1 is concerned, he's the father. No such allegations is against him from that parts. But at this stage, Lordship,
and this is otherwise case is registered under POCSO, I think.
yes,
Right.
so is there.
So in that case, notice.
He's
is
the
also
minor
being-
victim.
Yeah, he's minor.
Already I made the informant as a party lordship.
Hmm?
I made the informant as a party petitioner number, respondent number 2. Lord.
We have to issue
Call,
notice also.
issue notice to the, and in the meantime, kindly give me an opportunity to record my statement lordship. He's a minor
But
lordship.
to, that is why if your minor age is considered, then again, the question of anticipatory will come. So you are paid for anticipatory only.
That responsibility will take by the petitioner number, or he's the father. That's the responsibility never again happening this situation.
No,
It-
we are not
That is not,
or
no.
considering.
Court is not on that.
We are not on that. But 2 is direct allegation. Not only you are saying that they never meet each other,
No, lordship,
only over phone, but the
Lordship.
allegation says otherwise.
lordship, lord.
Allegation says otherwise.
Lord-
There was physical
Lordship.
relationship.
Allegation of rape is there.
Rape is the concern is there. That the part is those videos and obscene videos and photos were also taken.
Lordship.
That has already been made viral as per the FIR.
My
I
lord.
don't-
My
It is a serious allegation.
My
against you. Though I don't know how he is a minor or maybe minor. I can't. So what he is
My
doing
lord,
now?
already I had submitted the exhibit, annex the page number 13 is his birth certificate. Date of birth is 2/10/2008, lordship. And on already I specified in paragraph number 3, lordship, on the date of lodging the FIR, he was aged about 17 years, 7 months, 9 days.
It's very dangerous. Yes, we cannot say. So let we can at best father can be given some protection, but not the number 2, as you have, or otherwise you can withdraw this petition because he is still a juvenile.
Yes.
As per you, he is still a juvenile, or at the time of the occurrence he was a juvenile.
Lordship, I don't know withdraw. I don't want to withdraw the matters against the petitioner number
We will
2.
call for the
Fine.
otherwise case diary.
Fine.
Let us see her statement. Let
Fine.
us see her statement.
Give me protection the petition number.
One can be given some
lord.
protection,
My lord.
and you have to take steps for the 2 also.
My
heard Mr. R. Burba, the learned counsel for the petitioner, and also heard MS S.H. Bora, the learned additional PP, appearing on behalf of state. It is an application under section so and so in connection with so and so. It is submitted by Mr. Burba that the FIR has been lodged with some false and concocted allegations. However, it is a fact that there was a love relationship between the victim and the petitioner number 2, but they never physically met each other, nor there was any physical relationship between them. The petitioner number 1 is no way connected in the alias offense, though his name has been reflected in the though he has been incriminated in the petitioner number 2 is still a juvenile, and at the time of the alleged incident, he was 17 years, 9 months.
17 years plus 7 months, 9 days.
17 years, 7 months, 9 days. So, but both the petitioners are ready and willing to extend their cooperation in further investigation of this case if they are provided with some information. Ms. Bora, the learned additional PP submitted in this that there may not be any apprehension of arrest for the petitioner number 2 if he is a juvenile at the relevant time of incident. However, she submitted that the CD may be called for to know the actual facts. Considering this submission made by learning counsel for both sides, this court is the opinion that some interim protection may be provided to the petitioner number 1 till receipt of the case diary. However, no interim can be provided to the petitioner number 2 at this stage. Further, the petitioner is hereby directed to take steps to the respondent number 2 through the jurisdictional police station routed to the office of the registry and the public. Also call for the case diary. List the matter accordingly. 2020 of July. Your petitioner number 1 will be under interim.
Deeply applied.
Made, please, Your Lordship.
Yes.
Lordship, anticipatory bail application, FIR is at page number 10 here. May I read the FIR? Respected sir, I, Janardhan Paul, Vice Chairman of Lumding Municipal Board, hereby lodge this complaint regarding a lottery scheme organized under the name 2 number Sitlabari Sarvajana Shiv Mandir Parichalana Samiti, scheduled to be held on 31st of March 2026 at Shivbari, Lumding during the enforcement of the Model Code of Conduct for the Assam Legislative Assembly Election 2026. As per the coupon circulated among the public, the following individual is involved in organizing the said lottery. Mantu Devnath, contact number. It is respectfully submitted that the organizers are distributing donation coupons promising valuable prizes by collecting money, which may amount to inducement and raise serious concerns regarding legality and fairness. The event is being conducted during the enforcement of the Model Code of Conduct, under which such inducement-based activities are strictly prohibited. There is no public available information confirming that prior permission and no objection certificate has been obtained from the competent local administration. It is found that the said lottery is being conducted without valid permission NOC, then such activity would be illegal and may amount to cheating and fraudulent inducement by the public. Therefore, I request you to immediately stop and suspend the lottery event in view of the enforcement of the Model Code of Conduct for Assam Assembly elections. Verify whether valid permission NOC has been obtained from the competent authority. If no such permission exists, register a FIR under appropriate sections including cheating, 420 IPC and other relevant laws. Take necessary legal action against the responsible persons and organizers. The complaint is made in the interest of maintaining electoral integrity, preventing public cheating and ensuring strict compliance with the law. Lordship, at the time when this FIR was filed, that is 25th of March 2026. Prior to that, 4 months prior, Your Lordship, already in the same subject matter, the organizing committee had filed a writ petition before this honorable court, and by 26/11/2025, that is 4 months prior to the filing of this FIR, already notices were issued and the writ petition was sub judice before this honorable court, Your Lordship, over the same issue, that when the government had allowed conducting certain lucky draw open games in the events of any festivals, and the organizing committee has applied for a permission, but the DC did not grant the permission, so they approached this honorable court and the court issued notice. Thereafter, the court has also directed that yes, permissions may be granted at the end of the disposal of the writ petition, Your Lordship. In the meantime, Your Lordship, the informant, who is a municipal board chairman, without going into the details of this matter without understanding that there is a writ petition pending, without any examination, based on presumption has filed this FIR, Your Lordship. However, Your Lordship,
The order of the writ petition have you annexed here?
yes, Your Lordship, I have annexed. Kindly, Your Lordship, may come to page number 19th, Your Lordship. This is the first date when notices were issued. Page number 19 is the writ petition, 26/11, November, Your Lordship, 4 months prior to the FIR, Your Lordship. In page number 20, second paragraph is the main part, which says, it is the contention of the learned counsel for the petitioner that as per the order dated 11/11/2025, the Deputy Commissioner has to grant permission subject to the fulfillment of the conditions provided therein to conduct gift coupons or lucky draws for local festivals. Non-grant of permission for conducting a lucky draw to the petitioner is in violation of the order of the state government and will affect the celebration of Dol Jatra festival, and therefore a notice was issued, Your Lordship. In this time, the contention was that we have applied for NOC, the District Commissioner is not giving us an NOC, therefore we approach this Honorable Court. In the page number 21, Your Lordship, there is the next page. Here, our own committee, that is Dui number Sitlabari Sarvajanin Mandir Committee, in page number 21, annexure number 4, we have issued a public notice where we have said in paragraph number 2, the District Commissioner Hojai has not granted the necessary permission to conduct the draw on the previously announced date. In response to this, we have filed a writ petition, this and this, objective to the writ petition to seek a direction from the Honorable Court, and hence for where the matter has been postponed, Your Lordship. This is a public notice which we have given. Thereafter, Your Lordship, again on paragraph page number 22, annexure number 5, dated 23rd of March, that writ petition has been disposed of, Your Lordship. Thereafter, Your Lordship, when this writ petition was disposed, here the entire matter started, and in the meantime, that FIR remained pending, Your Lordship, and the inquiry was not done properly, and thereafter, again, we have filed another writ petition dated 3rd of June for understanding and calling the inquiry report, Your Lordship. However, in the meantime, due to the negligence of the informant, that FIR remained pending, Your Lordship, and the FIR was registered, Your Lordship. He did not go into the details of the matter and simply find an FIR saying that the model code of conduct has been violated. Now we are ready to provide all these documents same before the police inspectors, and we are ready to take and participate in the inquiry. Whereas in the meantime, in the writ petition also, the inquiry report and everything has been called for, notices have been issued. May we kindly be protected, Your Lordship. Completely civil nature, Your Lordship.
Lordship, the last order that is given by our High Court, Lordship, that is annexure 5, page number starts from page 24, the relevant page, paragraph 6, Lordship. It is the only directions from the court to take to consider the application for permission submitted by the petitioners in accordance with the guidelines laid down in the order dated so and so. Only permission was granted. So there is no such order. Stay order was there, Lordship, first of all.
Stay order.
Stay order is not there. That they can continue without getting the NOC. They can continue the lucky draws and all. There's no such order is given by our High Court, Lordship. So I may I again read 24, paragraph 7. In view of the above, the Deputy Commissioner Hojai is directed to consider the application for permission submitted by the petitioner in accordance with the guidelines laid down in the order dated so and so, and upon such permission, the draw can be held, which, however, has to be strictly in accordance with law. That is not yet decided. That is not yet over.
Indeed.
So in the meantime, they have, and the FIR has been lost against the petitioner.
Your Lordship,
At this stage, so I'm just praying for case study. Let us call for the case study.
Your Lordship, may I also
FIR has been lost, but FIR is lost on 5/3/2026.
Lordship.
And this
Order is
order of writ petition was
24, last order 24/2026.
23/4.
Yes.
Your Lordship, however, one more important thing, Your Lordship, the lucky draw never happened. It has not occurred till date, Your Lordship. There is no lucky draw game which has been conducted, Your Lordship.
24/2026 is the last order of the our Honorable Court, and the FIR was lost on
In the meantime,
25/3.
the FIR were already lost.
Yes,
already.
25/3/26.
Yes.
Yeah,
The
however,
matter is
Your
not yet decided. Only permission is granted.
no lottery is conducted, Your Lordship. The game did not conduct as of today, Your Lordship. That has, as it is pending, we did not conduct the lottery. That game, then the game never happened, Your Lordship.
Then why is the apprehension, Lordship?
So
It is
because
not
of the FIR, the apprehension is they're saying that at the time of MCC, Model Code of Conduct, we are going to conduct. However, without knowing the details, the informant has filed an FIR with utter negligence regards to the facts of the case, Your Lordship. And now when we are going to before the police, Your Lordship, we have to submit all the details. So the police is of the opinion that you rather take a anticipatory, but otherwise we might arrest you, Your Lordship.
But the FIR says that during this model code of conduct was already there.
Yes, it is already conducted.
They cannot be there. But
Indeed.
now you are saying that you have not conducted any
We have not
lottery.
conducted any draw of lots, Your Lordship. Because the writ petition is pending, second round of litigation is also pending, Your Lord. Second round of litigation is page number 26, dated 3rd of June, Your Lordship. The entire crux is whether permission will be granted or not. And without permission, we cannot conduct the said lottery, Your Lord.
So if you are not conducting, till date, if you have not conducted this
Indeed.
lucky draw
There is
Indeed.
competition, then case is not there.
Indeed, Your
Otherwise.
Lordship. That is why we are asking for a protection so that we can go and record our statement. Your
Because if it is not there, it was only an apprehension that
Indeed.
they have to be during that model code of conduct.
Indeed,
If any lottery draw is initiated, in
Indeed.
that case, there may be without any permission and all. That
Indeed,
was the
indeed.
main contention of the FIR.
Indeed.
So you are saying that you have not
Not conducted the lottery.
conducted any lucky draw competition there.
Yes.
But insofar as the FIR is concerned, it is reflected that it is found that, page 11, Lordship, it is found that the said lottery is being conducted without valid permission, NOC, then such activity would be illegal and may amount to cheating and fraudulent inducement of the public under section
Conducted,
420.
already conducted.
Already conducted.
So if the FIR is already
Did
conducted,
you call for
in the
anticipatory bail, Lordship? He is not behind the bar.
in the writ petition, Your Lordship, we have submitted an averment that it has not been conducted, Your Lordship. And the order of the district magistrate also says that it has not been conducted. It is an apprehension of the informant that it has been conducted. When it was conducted, which
If it
date,
is
which
not
venue,
conducted,
nothing.
Lordship, where is the apprehension comes? If it is
Indeed, Your Lordship. The FIR was
no
registered, Your
protection
Lordship.
at this stage.
May we
May we
kindly
have-
protect or record our statements, Your Lordship.
Had Mr. T. Lashkar, the learned counsel for the petition, also had MSSH work, the additional PP, appearing on behalf of state. It's an application under section 2 and it is submitted by Mr. Lashkar that the FIR was lodged on 25/3/2026. Only with the apprehension that the lucky draw competition may be conducted during the toll the festival. What kind of festival was there?
Dol Jatra, Your Lordship.
Dol Jatra, during the Dol Jatra by the organizing committee without prior permission and without obtaining any NOC from the local administration. But coming to know about the situation, the organizing committee had already moved an writ petition before this court, and before this court, which was registered as WPC triple six, no, Citus 666 2025, and where we order for notice was also notice was be allowed to issue the notice to the respondent side, and accordingly notice was also issued, and on by order dated 23/04/2026, the deputy commissioner was directed to consider the application for permission submitted by the organizing committee for to for the lucky draw competition. Full stop in this said. But prior to the order of but during the pendency of the said petition, without making any further inquiry, the FIR has been lodged on 25/2026. 2026. However, as per the resolution of the committee, one public notice is also issued. Until there is no lucky draw competition has been organized by the organizing committee. But all the petitioners are still ready and willing to extend their cooperation in the investigation of this case, and also ready to record their statements for the purpose of investigation, if they are provided with some sort of information. Ms. Gora, the learned additional PP raised objection and submitted that it is not a case that it submitted that from the FI itself. It is seen that the said lucky draw competition has already been organized by the committee and without any permission and NOC obtained from the local administration. Accordingly, she submitted that though the direction was given by this court in as per order of the WPC, but prior to that, the committee had already organized the lucky draw competition. Accordingly, she insisted, call for the case diary to know the actual facts. Next, para hearing the submission made by Lani for both sides and consider the annexures filed along with the petition and other aspects of the case. This court is of opinion that some interim protection will be provided to the present petitioner so that he can appear before the IF and can cooperate in the investigation. Okay, will be under interim protection.
Deeply obliged.
22nd of June.
Obliged, Lordship.
Adjournment allowing. Full to Nathan. Okay, go back. Move next issue. Go back. Okay. Yeah, look at the case again. Still move back. Hold it. Create. Then again. Create. Keep. Into. Keep. What is it? Ask.
Well, this matter may be taken up after some time, my lord.
Lordship, bail application in POCSO case, as per the office note dated 12th June, the service report is awaited, Lord.
Service is complete, my lord.
Completed. Na?
Okay, some amicus may be appointed, my lord. This is non-appeared for the information.
Okay. Heard Mr. A. Mishra, Ilana Council for the petition. Also heard Mr. R.J. Purva, Ilana Petition PP, agreement. As per office note dated 12/6/2026, service is awaited, but it is submitted by Mr. Borwa. That case, the service is already completed on the respond number. However, no one has represented the respond number in view of this. And accordingly, it is accordingly amicus may be appointed in view of this. Can be appointed to represent the respond number. Accordingly, MS S. Nazdin, Shahina Nazdin is being appointed as an amicus. That is, they will do the needful in providing the relevant copies to her. We need CD or scan copy, na?
Scan copy is the error.
Scan TCR has already been. Let the matter be according to it will be listed after vacation, but we don't have any space before vacation.
There's no time.
Because it is a charge-sheeted case, isn't it?
Yes, but
So let us be for immediately on 13th.
Lordship, any time on the next week, maybe.
What has happened? In 19, I have a matter that one matter is there. So whole day may be required for the death hearing. So 19, we are listing less numbers of matters. And by 25th and 26th, the order has to be passed. So we are listing less numbers of matters in those 2 days. We don't have any space. So let it be immediately on 13th September.
Since your Lordship, if the report had not, if the service had not been completed, your Lordship, then it would have been different. Now, since all of the things have.
That's why we submitted and we accordingly appointed the amicus.
Then
Let the matter be listed
Lordship
on
may
13th.
list the matter after a week to be decided by registry. If it accommodated, therefore.
After a week. After a week, as on a date we picked. Okay.
I'm obliged.
May I please, Your Honor? So, Your Honor, notice already issued to the respondent.
Notice issued, na?
but not returned yet.
Survey is not complete, my lord.
Not yet completed.
No, madam.
But one thing I just want to ask you, your this seal of from your office is not there. Have you received by your office?
My lord, that, my lord, we have only entered from the police station, my lord.
What process you have issued notice? It is a POCSO case?
Yes, Your Honor.
So which process you have issued?
To register you.
Why register it?
Register
And
it.
then how they will inquire?
Register it.
You cannot.
Taken
No.
to registry, madam.
Huh?
They have taken steps to registry.
Not to register, registered post, not to register.
That will not do, my lord.
That will not do. That's why there is no seal and this. And registry simple make a note there that a service report is not postal consignment is not. That much only.
Let them take fresh steps, my lord. For the
Should take
procedure.
steps, because how it will be possible now?
To
Case is
register
charge
it.
sheeted case,
No, Your Honor.
not yet charge sheeted.
No.
So till since when he is in custody?
11/5, Your Honor.
37 days, madam.
Already 37 days.
Yes.
So your process was not. That's why we cannot ask the.
We'll take.
Now you see the last the last item.
Yes.
They took the report and though it was not as per the officer, it was not sub, but they have the information that is already been sub. So we immediately appointed an amicus.
Step, Your Honor.
So within 2-3 days you take step. But obviously it has to be listed after vacation. We don't have enough
Already
time.
37 days.
Huh?
Already 37 days, Your Honor. Not
85
charge sheet.
okay. 85 days. Wait. Or we will await for the service also, no issue on that. But by that time, you also take steps. Okay. RMS speaker later, the done the petition. RMS Mr. R.J. Borwa, done additional PP appearing on behalf of state respondent. As per office note dated 12/6/2026, services awaited for phone number 2. However, from after inquiry, it has come to knowledge that the notice was issued through the registered post. And accordingly, the petitioner is hereby directed to take fresh steps on the response number 2 through jurisdictional police station routed to the office of the registry and the public registry. Please the matter accordingly. 25/6. Let us see. In the meantime, if the other service report is
But it can it be on 26 or 24, not 25?
24.
Of like-
26 we are not listing.
May please, your lordship. The regular bail application, lordship.
Yes.
The recovered quantum is the ganja, lordship. Our quantity is 5 kilo, 2.29 grams, lordship. So this is
Yeah,
behind
feeding
a bar
the
for
receipt.
last of
Just a
50.
second. See the receipt?
Item number 21, searches submitted, madam.
Oh. Okay. Charge is submitted. Mr. A.K. Gogu, the learned for the petition. Mr. R.J. Borwa, the learned additional PP appearing on option. Is submitted by Mr. Borwa. That case has already been charged by CS number.
By CS number 33/2026, dated 29/5/2026.
In view of the petitioner is hereby directed to make a application for regular bail before the learned trial court below. Learned trial court below, which may be considered in accordance with the observation in present bail petition stands disposed.
Obliged, lordship.
Okay. It is style of now. Order column of the asset. He was style of the order column. বলতো পাঠ পড়াই নাই আমি কই শোনা নাই পাঠ লিখতেও দেখা কেউ টেনে দিত যদি কই তেনেকে কথা নহয় না আমিতো কৰি আছো কাম চলি আছে। part time লগত বহুত। ভাবিছো মই part time কেতিয়া কৰো মই আৰু মোৰ অৰ্ডাৰ part time লিখিব লাগিব। আমি কিবা কথা কাৰণে এইটো 2 PM কৰিছো। there may be a কথা different. Anyway, চাই লওক আৰু সেইটো
Wait, please, Your Lordship. Lordship, in this case, when a TCR was called for, perhaps it is not received, my lord.
Okay, see that. Is there any official your pricing? You are MS?
PM Ahmed.
Hard MS PM Ahmed, and a council deputy. From the office note dated 10/6/2026, it is seen that the scan TCR is still awaited. And it has not been still awaited. Post in view of this, let a reminder be issued to the concerned court with a direction to furnish this scan TCR on or before the positively on or before the next test. Registry will do the need estimate accordingly. It will be obviously come after vacation only. We don't
Well,
have
immediately after vacation then?
Yes, obviously. 15/7.
Hello. God bless you.
May I please, Your Lordship? Lordship, this bail petition is preferred in connection with NDPS case number, Your Lordship, 56 of 2026, pending before the Special Judge Kasar, arising out of Lakshmipur PS case number 4026. The quantity is intermediate one. Page 20, Your Lordship will find the seizure memo, seizure list. To 20 grams suspected heroin. Your Lordship.
Commercial is 250.
250 grams. And Your Lordship, if Your Lordship may go to page number 28, Annexure 3, which is the arrest memo. There is violation of section 36B1. No signature of witnesses or family member has been taken in the arrest memo.
Which page?
Page 28.
This is the arrest memo?
Yes, Your Lordship. Serial number 6, no signature of relatives or witness. And today is 101 days I am behind the bar.
And then 1 days.
Yes, Your Lordship.
What is the stage of the case? Can you tell us?
Yes, it is for production, Your Lordship, production of accused.
Charge is already framed or not yet?
Yes, Lordship.
Charge framed or not yet?
Not yet.
Not
As
yet.
per my instruction, it is pending.
My lord, I have verified from the record, my lord. The 48 notice, my lord. The 48 notice, my lord. The signature of the family member is available.
They have taken signature.
Yes,
But
my
in
lord.
arrest memo.
Arrest memo, it is not there, but 48 notice has been complied with, my lord. 48 and 47, my lord. And my lord, there are some, my lord, order passed by this honorable court, my lord. The 48 notice has been complied with, my lord. It is not necessary that, my lord, it's a 36 notice is not complied with, my lord. Because, my lord, 36 notice also, my lord, it was issued to the family members only. But sometime, my lord, what happened, my lord, 48 notice, they have received, my lord, family member. So information, my lord, they have received the information, my lord. As part of mandate of section 48, my lord. So I'll place those judgments, my lord, let it come day after tomorrow, if required.
Yeah, tomorrow.
After 4, oh, my lord, I can place it today itself, but after some time.
Okay, that is the, you want to say that compliance of 47 and 48 is there, no, but the signature of this
Family members is.
family member in 36 is not there. That is the case.
My lord.
Anyway, what is the stage of the case?
Case of that case, my lord. Charge is yet to frame.
Charge is yet to be. Any on merits of the case you want to submit?
On the quantity and on the length of detention. Yeah.
But this recovery was from his conscious position.
My lord, I have made a statement that on the in paragraph number 7, that on the very fateful day, I was coming from a marriage ceremony, and the co-accused who fled away from the place were also coming in the vehicle, and I took lift as they were from my own locality. And in the meantime, the Naka checking was there, and the vehicle was intercepted, and the other accused person fled, but I was taken into custody. That was my
So
submission.
you want to say that there was no direct
No connection,
recovery,
direct connection.
recovery was not from the
Yes.
conscious
The
position.
other co-accused person fled the place.
Oh. Yes, or any other assumption.
The my trial is yet to commence, my lord. And my lord, as part as my lord, section 47 and 48 notice, my lord, 47 and 48 notice are complied with, my lord. And secondly, my lord, the contraband, my lord, although it is not commercial in nature, my lord.
About to be commercial.
Yeah, 220 grams of heroin, my lord, and it is recovered from his possession, my lord. And co-accused is yet to apprehend, my lord.
Till the co-accused are apprehended, it will take time because they are absconding, and I am ready to face the trial also.
You are RS or MR?
MR.
MR. Yes. Oh, sorry, MS. She is.
Yes.
I heard Mr. MR Sodia, the learned for the petition. Also heard Mr. RJ Burwa, the learned additional PPA to respond. This is an application in the section so and so in connection with so and so. Scan copy of the set has already been received by Mr. It is submitted by Mr. Sodia that the present case is that the present accused petitioner is innocent and no contraband has been seized from conscious position of the present petition. However, it is the fact that the very fateful day he took a lift from in a car wherein the contraband was there, and when the police made a narco checking, the other two. And when the police made an narco checking, the other the co-accused has already been fled away.
No, there is no other accused, my lord. He is the only accused person.
No, he was arrested, but there were two persons also.
But they have not been shown as an absconder, my lord. That was as seeking.
Charge sheet is filed only against him.
Only against him, my lord.
Only against him, but on the very fit with the vehicle where.
Anyway, but the other two occupant of the car had fled away, and this petitioner got arrested, and along with the contraband. However, the quantity of the contraband which has been seized from the possession of the alleged to have been seized from the possession of the accused petitioner is 220, na?
Yes,
220 gram of heroin, and is it's of intermediate quantity. He further submitted that the accused is behind the bars since 101 days, and case has already been charge sheeted. So, charge is yet to be framed. Full stop.
The lordship, a small submission. In the charge sheet, name of the other persons were mentioned in the brief of the facts of the case. That
It is mentioned, they have
yes,
not been charged with.
they are not
Charge
charged.
sheeted.
Yes.
Full stop. He further submitted that while issuing the notice, there is no proper compliance of 36B BNSS while issuing the arrest memo, and the signature of the family members were not obtained at the time of issuing the arrest memo, which violates the provision of 36B PNSS, and in view of that also he may be released on. That apart, he submitted that the accused petitioner is in custody for last 101 days, and hence considering his length of detention also, his prayer may be considered. However, he is ready and willing to appear before the learned trial court below on each and every day to be fixed by the court. Next, Mr. Purva, the learned additional VP, raised objection and submitted that there was a proper compliance of section 47 and 48 of the PNSS, whereby the family members of the petitioner was intimated immediately prior to his arrest and arrest. However, the arrest memo, in the arrest memo, there is no signature of the family members, but that cannot be the sole reason for considering his bail application on the present petitioner, where there is a proper compliance of 48 of PN.
No prejudice has been caused, my lord, that may be.
As there no prejudice will be caused to the petitioner for not taking the signature of his family, friends, or relatives. Mr. Purva further submitted that the charge is yet to be framed, and the charge is yet to be framed, and it is very initial stage of the trial. Mr. Purva further submitted that though the case is registered under the intermediate quantity, but the but on 220
I'm sorry,
grams
my lord, charge already framed, my lord.
charge framed.
Yes, my lord, on 12/6/2026, it is fixed for evidence.
12/6
12/6, my lord.
charge frame for review. 12/6 is the date fixed for evidence. Till date, 12/6 is the date for evidence, and hence the case is at the very initial stage of that. Apart, the quantity of the contraband which has been recovered from the possession of the petition is much more than the small quantity, and as the commercial quantity is of 250 grams of heroin, considered to be 250 grams of the heroin. Mr. Burwa accordingly raised payment objections, submitted that it cannot be a case for considering his bail application at this stage without recording the evidence of the vital, recording of the vital witnesses of the prosecution. You just submit, I'll pass the order as per your submission. I have already recorded. Mr. Burwa, if you have any, you just submit.
My lord.
Order.
45, my lord, there is some mistake in the order, my lord, that I have already informed the, my lord, private secretary, my lord. Because in this case, charge is yet to frame, my lord.
I was initially, it
Yes.
was written down,
Yes,
the charge is yet to frame, and then
But
you
there is
say-
a note, my lord, that is why, my lord, I thought the charge was framed, my lord, but the charge is yet to frame, my lord. And
you
matter
say
has,
charge is framed and next date
yes,
is
my
on
lord.
12
No,
days.
it is not, my lord. That is a mistake, my lord. And matter is not fixed for evidence.
No,
Well, 45 is disposed of, my lord.
we'll try to pass
Ma-
in order.
My lord.
Item number.
Lord, in this case, petitioner is in interim bail, my lord. FIR space 12, my lord. Last page of the bail application. Actually, he's a tuition master, my lord. My lord, actually, he wanted to receive, my lord, some amount of rupees 8,000 in a year, my lord, in the tuition, as a tuition fees. But as he told, my lord, her mother, my lord, of the victim girl, mother, my lord, filed this case, my lord, instigating her daughter, my lord.
My lord, in this case, my lord, TCR was called for, my lord, and the TCR has been received, my lord. In the TCR, my lord, only the 183 said, my lord, the victim card is available, my lord. Apart from that, nothing is available.
Nothing is there.
No, only 182 statement by the victim. And victim is
Otherwise, it is a charge-sheeted case.
Charge-sheeted case.
charged.
Very simple, short incident, my lord. It is mentioned in the FIR that he petitioner, my lord, tried to, my lord, misbehave her, my lord, by touching her.
That she has implicated in by 182.
Why it is there only this thing? Anyway, you are on interim.
Interim, my lord.
Interim was prior to charge sheet or after charge sheet?
Prior to.
Prior to charge sheet.
Prior to charge sheet. Because, my lord, he, according to in the FIR, there is not any specific allegation, my lord. Only just, my lord, he kindly peruse the last page, my lord. বিনীত নিবেদন এই যে উপৰোক্ত পদকীয়জন মোৰ টিউচন শিক্ষক হয় বৰ্তমান মই দশম শ্ৰেণীৰ ছাত্ৰী যোৱা 21/1/2026 তাৰিখে ৰাতিপুৱা প্ৰায় 11মান বজাত পদকীয় মোৰ গাঁৱৰে পথত লগ পাই মোক গণিত শিকাই দিব বুলি কৈ মোৰ ঘৰত আহি মোক অলপ সময় গণিত দি মোক হাতত ধৰি জোৰপূৰ্বক বুকুত হাত দি মোক শালীনতা নষ্ট কৰাৰ লগতে মোক চেষ্টা কৰে পিছত মই চিঞৰ বাখৰ কৰাত তেওঁ মোক এৰি দি দৌৰি পলাই হাৰে আৰু এই কথা অন্য লোকক কৈ দিলে মোক প্ৰাণে মাৰিব
Next,
বুলি
charge sheet also here. Charge sheet is here.
Charge
Oh,
sheet
charge sheet is not there. Oh, it's not here
It
now.
is not there, man. Only
Oh,
the
it should be
182.
cleared now.
That may be called for, man.
Yes, Mr. Doctor, we want to submit anything.
And if you are for the respondent, the object.
You have already filed the objection. You have received the copy of the objection.
yes, but there is not a two-page he has filed objection
You have received the objection copy of.
yes received. Nothing mentioned.
Okay, now what I want to see, in fact,
Yes, ma'am.
he was already on interim, but during that period, case has
Charges
already been
submitted.
charged. So we want to see that in the charge sheet whether his cooperation is there, or he was even after obtaining the order of interim, whether he did not cooperate or cooperate.
Already
That is to be seen.
yes
But that is not
cooperated,
there.
my lord.
And my lord, since my lord, charge sheet was filed, my lord, on 29/3/2026, my lord. So status of the case also will be clear from the scan copy of the record. Because whether the victim is examined or not.
No, victim won't be examined. He has not appeared. No. You have not appeared before the.
He appeared.
Yes.
No,
Statement recorded.
not before the court.
Not
Have you
not
received
before
the
the
summon? No.
no not received someone.
Okay, then we need the record. How
My
will you
lord,
pass
yes,
the order?
the record will be postponed.
Yes, anything to submit? Mr. H. Das, the learned counsel for the petitioner. I also heard the R.J. Burwa, the learned additional PP, appearing on behalf of State Respondent, and Mr. Jed Ratna, the learned counsel, appearing for the responding number 2. Though as per the office of the scan TCR received, it is submitted by Mr. Burwa that accept the statement of the victim recorded under section 183 BNSS. There is no there is no relevant documents or record of TCR. In view of this, the registry is hereby directed to issue a reminder to the concerned board with a direction that to furnish the entire scanned copy of the TCR. And it is also to be reminded that scanned copy of the TCR does not mean only the statement of victim under section 183 BNSS. Registry will do the needful. However, it is submitted by Mr. Das that the accused is in interim under the interim protection, and during pendency of the present application, the case was already charged. In view of this, let a scanned TCR be called for along with the present status of the case, and present status of the case post. When it can be after vacation?
27, 20.
20/7/2026, interim be continued till next day.
Proxime on the
তার মধ্যে আরোটা লেখো। The learned, respondent number 2 has already filed a written objection and copy has already been served to the arrested.
Proxime only add, my lord, scan copy of the TCR along with the case diary.
Scan copy of the TCR along with the case.
Much obliged.
Obliged.
May it please, your lordship. Lordship, in this case, the petitioner, my lord, is an agent under the United Insurance Company Limited. My lord, being an agent, he has issued one insurance policy in respect of a vehicle of Mahindra pickup, my lord, ML085091. Lord, what he has done, one mistake he has done, instead of four-wheeler vehicle, Mahindra pickup, he has written Bajaj Auto bike, my lord, two-wheeler. That was his mistake. In this regard, the company, my lord, is now saying that he has forced the same, my lord. Only mistake in terms of interim order, my lord, page 2 for 2026, I have already appeared, my lord, and cooperated. My statement is, I think, also recorded, my lord. My lord, my case is seen, this is a case of record. Nothing.
Otherwise, my lord, yes, my lord, his statement is there after interview he has appeared. But fact is that, my lord, during the, my lord, a case was there for claiming compensation before the MSCT tribunal, Dhubri, where it was detected that the vehicle is, it should be a bolero vehicle, but the insurance document has been shown as a two-wheeler vehicle. Thereafter, it was detected, my lord. To getting the compensation, my lord, amount was paid. Now, as it is detected, my lord, subsequent, my lord, it was no money has been disbursed, nothing, my lord. That is there. But he has appeared statement recorded. He stated that it by mistake. It's under investigation still.
I also admit that there was a mistake. Only instead of four-wheeler, it has been written two-wheeler.
Otherwise, my lord, fortunately, it is detected and no any compensation amount, nothing has been given.
In MSC case?
Nothing has been given, my lord.
But the vehicle registration number was same?
Number same, but it is shown as
Two-wheeler.
two-wheeler. It should be bolero pickup. An accident occurred. Actually, the accident occurred of the bolero vehicle. No any two-wheeler.
Or during the at the time of MSC case only?
Bolero vehicle got made it inactive.
Since I am cooperating, I am ready to cooperate in future also if required.
Heard Mr. M.R. Dekar, the learned counsel for the petition. Also heard Mr. K.K. Parashar, the learned additional PP, appearing on behalf of state respondent. This is an application, the section shows connection with CD received, bill is received. Next part, it is submitted by Mr. Khandekar that after obtaining the order of interim pre-arrest bail dated 2/4/2026, he appeared before the IF and cooperated in the investigation. Mr. Khandekar further submitted that the present petitioner is a insurance agent, and it was only under his bona fide mistake he issued. The vehicle is wrongly reflected as bona fide mistake. The vehicle in question was wrongly reflected as two-wheeler vehicle instead of Bolero pickup van. Though the registration number and other particulars were the same. Stop. He is further ready and willing to extend his cooperation if needed. If needed. Next one. Mr. Parashar, the learned additional PP submitted in this report that the mistake was mistake was the mistake was found out at the time of filing the MSC case, wherein the said Bolero pickup van was alleged to have been involved in the accident. However, however, the petitioner has already appeared before the IM and extended his cooperation. Next, but considering this submission made by learned counsel for both sides and the other aspects of the case, and from vis-a-vis the materials available in the case diary, this court is of opinion that study interrogation may not be necessary for the interest of investigation. In view of this, the order dated 2/4/2026, the order of order interim pre-arrest bail dated 2/4/2026 is hereby made absolute with same terms and conditions.
I am deep.
May I please your
Petition
lordship
for
kindly
office
pass over
notice
the
there,
matter
na?
for the time being. My senior is on another court.
If in opposition, file. So you have already filed your affidavit, huh?
Yes.
So case time taking for time being.
Let it be on Friday or Monday. I'm not some other.
Friday, Friday. Oh, Friday not possible. One
Monday,
matter is there.
or Tuesday, any.
Tuesday ki tarikh? 23rd. 23rd. 20. At the request made by counsel for parties, let the matter be accordingly listed on 23rd, so and so. However, from the office, it is seen that the respondent side has already filed their written of affidavit in opposition. So, okay then.
There was CD available, मतलब none appears.
Tiang Puna na
26.
Mr. Abdullah, your case is 26. We call thrice. You are not there. Your name is there. That's why we asking.
Wait, please, Your Lordship, my lord. Actually, this case was engaged by one with the J. Ali, my lord.
Oh, J. Ali
He
is
did
there.
not inform me, so I also overlooked, man. Let it be passed over, man. CDA, Sakshi, I think.
We have received the case diary here.
My lord. Actually, my lord, there is a note of the IO, my lord. Interim is there, my lord, they have appeared. Note of the IO, it is noted that the accused 2 and 3 number of times they have appeared and statement already recorded. So I have not recorded the statements this time and released them after serving notice 35(3) and BNSS to them. Next date of appearance so further. On further appearance, 35(3) notice has been issued against them, my lord.
No, by how he can again issue 35(3)?
For asking them to appear, asking them to appear in any.
No, 35(3) can be issued for if there is any needed cooperation. But it seems that prior to that he already appeared. After that also he said that there's no necessity as already recorded. Now again 35(3) is issued. I mean,
Statement
recorded.
Statement recorded, their statements are there available. Prior to the interim order, their statements are available.
Yes. So that's why he had not recorded. But again, he issued again 35(3).
Notice.
Why?
Otherwise, they have appeared, the statement recorded.
Okay, then we can dispose.
Lordship,
We'll record your name on.
Lordship.
Heard Mr. S.M. Abdullah P. did an petition. Also heard Mr. K.K. Parashar did an GP appearing on behalf of. This is an application under section Swenson in connection with Swenson. It is submitted by Mr. Abdullah that the accused petitioner has already appeared before the IO prior to the after receiving the notice and after obtaining the order of pre-arrest bail also they have interim pre-arrest bail. They have also appeared before the IO for cooperation. Most of they are still ready and willing to extend their cooperation if they are provided with privilege of pre-arrest bail. Next one, Mr. Parashar will an additional PP submitted in this regard. That from the case diary as well as from the note of the IO, it reveals that prior to the order of interim pre-arrest bail, the petitioner has already appeared before the IO. Petitioners have already appeared before the IO and their statements were recorded. And hence, subsequent statements was not recorded by the IO, though they appeared before the IO after obtaining the interim order. Next, considering this submission made by the counsel for both sides, materials in the case diary, the order of interim pre-arrest bail dated 4/5/2026 is thereby made absolute with same terms.
Obliged, my lord.
May it please your lordship. Lordship, I am on interim in this matter. We are on interim, your lordship. We have appeared before the IO and our statements were supposed to be recorded, your lordship. And your lordship, this is a matter where your lordship, the informant and his associates were constructing a road, your lordship. And the petitioner number 2, who happens to be headmaster, your lordship, of a school, complained about the rampant corruption that has been taking place while constructing the road, your lordship. Thereafter, a quarrel happened. And your lordship, then his family members, the petitioner number 2's family members came to his rescue. And thereafter, this informants and all, they just to threaten them, your lordship, they went to the they filed this FIR, your lordship. And others, your lordship, allegations of extortion and all are, your lordship, that those are immaterial, your lordship.
As per the allegation in the FIR, there are after the modesty of a woman that is there, but they are all 11% they have appeared. The statement all recorded. They have denied nothing. Some altercation took place here and there, and witness, several witness. Some witness stated that something is there. Few have stated that we didn't say anything, but some altercation something. All have appeared,
What your medical report said?
Medical report, 1%. Yes, yes. That's no external injury detected. No external injury.
While your lordship, this FIR was filed just to suppress the voice of dissent, your lordship, against the corruption, your lordship, that has been taken place, your lordship.
4% medical report is there. One is swelling and blunt object, and other 3 no external injury.
Heard Mr. M.I. Hussain, the learned counsel for the petition. So heard Mr. K.K. Parashar, the learned respondent. CD receipt, parents receipt. It is submitted by Mr. Hussain that all the petitions have appeared before the IO after obtaining the order of pre-arrest bail and cooperated in the investigation of this case. He further submitted that except some altercation and quarrel between 2 groups, no such incident happened as alleged in the act. He further submitted that petitioners, being the responsible people of the locality, only raise objection in financial misconduct while constructing the road by the informant, and on that context only, there was a quarrel between the two groups. However, they are still ready and willing to extend their cooperation if they are extended with privilege of pre-arrest. Next, but Mr. Parashar, the learned additional PP, submitted that that there is a some quarrel and altercation took place between two groups, and that apart there is no such incident by two groups, and some of the persons were stated to be injured. However, as per the injury report, one victim sustained simple injury and no physical injury was detected at the time of examination of other three victims. We further submitted that all the accused petitioners have appeared before the alia and extended their cooperation during investigation. Next, but hearing the submission made by learning counsel for both sides, considering the materials available in the case diary, vis-a-vis the medical report, and other aspects of the case. This court is of opinion that custody interrogation may not be necessary for the interest of the investigation. And the order of interim pre-arrest granted to the petitioners dated 5/5/2026 is thereby made absolute with same terms.
Your Lordship, my name may be recorded as MD.
MD means what?
Muhammad.
Yes, all are Muhammad, I think.
Yes, Your Lordship. Sorry.
I mean, most of the
No,
Muslim,
Your Lordship.
not.
No, Your Lordship.
I mean, there's difference.
Yes, there's difference. Everyone's name doesn't start with MD, Your Lordship. It's not just a prefix, Your Lordship. It's a part of my name.
Sure.
Yes,
I do not know about the test differentiation. Anyway, if we address some say Muslim person,
okay,
then maximum says that Muhammad so and so is not. It is not there.
Oh.
It should not be there.
No. No. There are many names, Your Lordship, where MD is not written before. There are many names where MD is part of the official documents, Your Lordship.
But suppose being a Hindu
Yes,
religion follower of Hindu,
yes, sir.
he will be addressed as Srimati or whatever.
Yes, Sri or Srimati, that is will be something like Sir, or Janab, that is different.
Sir Janab.
Sir or Janab, that is different. It is.
No, we rather than Srimati.
Yes, Your Lordship.
And the follower of Muslim religion, they generally start Muhammad so and so. So you said that Muhammad is not for all.
Not for all, Your Lordship. No.
Oh, that I don't know. Is it?
There are many names. There are many names where Your Lordship will not found Muhammad before the name. There are many names, Your Lordship.
Yes, Mr. Abdullah, would you say? I'm confused. That's why I'm just asking.
I think he's
I got the limited knowledge, but I don't know much. But my name is Sheikh Muhammad Mana. But in most of the cases, people write Muhammad so and so,
Yes.
Muhammad so and so, Muhammad so and so.
Muhammad so and so. Generally, what I'm
Your Lordship, now he said that his name starts with Sheikh, not Muhammad. His the second word is Muhammad. So that is.
But for suppose
there are many
suppose
names.
my name is suppose my name is suppose Abdul Hussein, suppose.
Yes.
Muhammad
So I will never be written as Muhammad Abdul Hussein.
No, there are many documents, Your Lordship, where Muhammad is not a part. Even there are some names which starts with Muhammad Hussein. So Muhammad is a name. So Muhammad is a name of.
No, Muhammad is a name also.
Yes,
I understand. No issue.
So
with that.
Muhammad is
a name
written.
also. Even Hussein is also a name.
Yes, yes.
Like that is there.
Yes, sir.
But Muhammad for every
No,
is
Your
not there.
Lordship, no. Officially, someone may address someone as Muhammad. That's a different. But in official documents, it cannot be Muhammad, because he only said for his name. Muhammad is not a part officially not a part of his name.
That I confusing.
I have limited knowledge,
No, we are also on limited knowledge that we know that for every suppose in Muslim that's Sri Srimati instead of Sri.
These are
It's a Muhammad generally.
These are part of.
Generally, everyone writes Muhammad.
Muhammad. So we are on that conception. That's only I just asked you. So you are Mr. MD.
MD, I say.
MD, I say.
Yes.
Okay, then we'll write. No issue on that. But MD I Hussain, but I thought that MD is for everyone, Mr. Interested.
Actually, MI Hussain is someone else, Your Lordship. Your Lordship asked him to record MI Hussain. MI Hussain is a different counsel, Your Lordship.
No, MI Hussain is a different.
Yes, sir.
You are Mr. MD I Hussain.
Lordship.
Okay, then. Oh, okay, we'll remember it because I was not. I had no knowledge about that.
Right.
Anyway, MD I Hussain.
May I please, Your Lordship?
Yes.
It's an anticipated bail application, Lordship.
Yes, whatever
City was
is
Lordship.
AB 28.
Your Lordship, FI is at page
Just a
15.
second. CD available. Yes, FI is at.
Page 15, Lordship.
You are on interim. You are not
No,
on
Lordship.
interim.
No, Lordship.
FI is at page.
15, Lordship. The FI date, Lordship, is very important, Lordship. 6/6/2025, Lordship. FI regarding the sitting criminal misappropriation and criminal misconduct, Lordship.
FI is of 6/6.
15, Lordship, page.
FI dated 6/6/15.
6/6/2025, Lordship.
6/6.
With due respect, I have the honor to report you that one series so and his father, Dhiren Borua, and Liton Borgohain, Lordship, offered us to donate 2 numbers of male domestic elephant to our temple at Kerala for worshipping them as per Hindu religious rituals for our temple, with the condition that we have to pay them the transportation and documentation expenses. We readily agreed to their proposal and we paid our first installment of expenses to the accused Dhiren Borua on 4/3/2024, rupees 40,000 through GPay and 10,000 in cash in his hand. The transaction was done, Lordship, 4/3/2024, Lordship. Later on, they asked for more money for processing and documentation, and we paid them lastly 50,000 on 17/6/2024 in their bank account. And in this period, they have taken from us rupees 1.23 crore only on different dates. The bank statement is filed with the FIR, but our repeated request to them, the transportation of elephant, they were took time on this or that pretext, like that they have doing the documentation work, etc. And very soon they would send the elephant to our temple, Lordship. Here, Lordship, the FR date is 6/6/25, Lordship. The incident taken place, Lordship, on 4/3/2024, Lordship, which is the amount is transferred in the name of in the account of the petitioner's father, Lordship, and the petitioner father already arrested, Lordship, and he was behind the bar, now released from the jail, Lordship. The present petitioner being the son of the prime accused, Lordship, his name has been dragged in the FIR, Lordship. From the plain reading of the FIR, Lordship, it is very much clear that the petitioner father has taken the money, Lordship. And the bank statement also already there, Lordship, annexed with the FIR, Lordship. And Lordship, the 1 year, Lordship, the FIR has been lost, Lordship. Sufficient time of investigation was done, Lordship, may be completed,
Well,
Lordship.
the rest
till
part
date,
of the
Lordship.
FIR, what it says, the later part of the FIR in page 16.
Page 16, Lordship. Basically, the accused forged the seal. 3 accused person was there, Lordship. My father, Lordship, me, and one Litan Borgohain, Lordship. The forged seal and signature of the office of the principal conservator of forest, Lordship. And since last 10 days, Lordship, I have been in Tinsukia and trying to contact the accused person, but when I visited their house, they fled away by locking their house. I visited their house so and so date, Lordship. Lordship have to look into, Lordship, whether the amount was deposited or credited in my account or not, Lordship. It has been looked into, Lordship. Yes, Lordship. And already, Lordship, FI stated the
The bank statement already with the FIR, Lordship.
At least along with. It is along with the FIR.
Along with the FIR, Lordship, it's FIR is stated, Lordship.
Bank statement, you have not annexed it?
Yes, Lordship, I have not yet, Lordship.
Acha, it may be available in the case.
Yes,
right?
it may be, Lord.
So your basic case is that though
My
your
father is involved, Lordship, he has been arrested,
not
Lordship.
related, your father had received the money
Yes,
and he
Lordship.
already got
Yes,
arrested.
Lordship. But not 1 crore.
And regarding this,
For
the
transportation
forgery
and
of
documentation, my father has
your
taken.
forgery of this seal and signature, in that context, what do you want to submit?
The 3 accused persons are there, Lordship.
So you are not at all related?
Yes, Lordship.
Okay. What's your name?
Yeah, Lordship. Oh, yes.
No.
Yes, Lordship, he is
Santosh
Santosh Lordship.
Santosh Bor, alias Chiranjeev. Yes.
Lordship, so far as the allegation against the petitioner is concerned, Lordship, the petitioner is alleged to have contacted with the informant regarding transportation of 2 male elephants.
He made contact.
Yes, he has contacted with the informant regarding transportation of 2 male elephants to one of the temples in Tamil Nadu for the purpose of worship, and thereafter, Kerala, I'm sorry, thereafter assured delivery, and thereafter collected necessary documents from the forest departments of Arunachal Pradesh and received a substantial amount of money from the informant, Lordship, and thereby they have cheated by not transferring those 2 elephants who were supposed to deliver for the purpose of worship in the temple. So to that regard, Lordship, I have found the IO's note. It has clearly stated that, may read the note of the IO. It is to be noted that upon transfer of the previous investigating officer so-and-so, on perusal of the case diary, it is revealed that the previous IO examined the complainant and recorded his statement under section 180 BNSS. I also arrested the accused person, namely Thiren Borwa, and forwarding him to judicial custody, the father of the present petitioner. The complainant produced a copy of an authorization letter issued to him by the authority of Sri Tripanayam Devi Temple for procuring and collecting all necessary documents from the forest department and other relevant authorities, the transportation of an elephant from Assam to Kerala. The complainant has also submitted bank statements, copies, and screenshots of payments made to the alleged accused persons. Upon analysis of the bank statements, it has been observed that the complainant made payment to the accused persons, Santosh Borwa, to the present petition, and Linton Burahagohe, along with Thiren Borwa, the father of the present petitioner, on several occasions. The total amount such transaction is calculated to be rupees 40 lakhs 22,500. So as in the FI, it has been stated that it was more than 1 crore, but on papers, on record, it has been shown that the transaction was near about 43 lakhs 22,500 rupees. So apart from these transactions, the complainant has also stated that he paid certain amounts in cash. However, such cash payment is reflected only in his personal records, not in any independent documentation. That will leave, Lordship. Further investigation reveals that the complainant made payment not only from a single bank accounts, but from 3 to 4 different bank accounts. And these payments were transferred to multiple bank accounts held in the name of Santosh Borwa, Thiren Borwa, and Linton Borwa.
In the name of account?
3 persons. Equally lost.
Joint account?
No. They're in their different separate bank account, Lordship, in their own individual names, Lordship. The IO examined witnesses and recorded their statements under section 180 BNSS, but the mobile number of the accused persons were also collected, and it found that the mobile number so-and-so belonging to Santosh Borwa are currently found to be switched off. And it is pertinent to mention that call details records of mobile number so-and-so has been also obtained. And thereafter, Lordship, so far as CDR call reveals frequent communications among the accused persons and with the complainant during the relevant point of time, the date of filing of the FIR. Notices under section 494 BNSS has been issued to various bank accounts for collection of account details and transaction reports. So investigation still is going on, Lordship. And it is also pertinent to mention that accused Santosh Borwa has remained absconding. He was found to be at large during the whole investigation period. And his 2 known mobile numbers was found to be switched off. He is evading. His intention is very much clear that he is evading police arrest, police apprehensions, and he is, Lordship, He's evading the arrest, Lordship. He's not willing to cooperate with the investigation and the process of law. And thereafter, Lordship, now I'm objecting his bail petition at this stage because many other relevant documentary evidence is yet to be collected. And Lordship, financial records, banking documents, and CDR analysis regarding in respect of other mobiles who is presently using. So that is also very important to collect. There are every possibility of hampering and tampering with the evidences as well as the witnesses, because there is a big nexus, Lordship, of this transportation of elephants from one state to another state. In lieu of that, Lordship, they have cheated.
So, okay, then
so
that
many
apart, I
persons,
just
Lordship.
want to ask you one thing. There's another allegation against these accused persons that they have
Yes.
was not only they extract money from there without even transporting the elephants.
Yes.
That apart, they forged the seal and signatures of some of the officials of the principal conservator.
Yes, Lordship.
Wherein they showing them that they are the owner of 2 male elephants.
Yes.
Whether that is there in that context, whether there is any investigation.
Yes, Lordship, I have the case record up to Lordship 18/3/2026. So to that regard, Lordship may give a specific direction, and on that, to that regard, I'll receive the instructions from the concerned line. It may be up to the CD, maybe
18/3.
It was up to 18/3, Lordship.
18/3/26.
Yes, Lordship.
Lordship, the
Yes,
total
Lordship.
case is based on documentary evidence, Lordship. The bank statement and the other documents are maybe there, Lordship.
So
And
you
my father also
were
interrogated
issued
Lordship.
94 also, but you have not appeared.
Lordship.
94 was
The
issued. It was
amount,
the best
Lordship.
option for you also to produce all the documents before the police authority.
Yes.
I mean, investigating authority,
Lordship.
because 94 was also issued
So,
to you.
Lordship, if
So
Lordship,
that opportunity could have been availed by you also.
Yes, Lordship.
That was there, but without avoiding, but without that complying that those 94 and all, just you are avoiding and switch off the mobile phone so that no one can contact
Yes,
you. Are now using another mobile hands.
That indicates he is evading.
Your conduct, you see, the conduct.
Yes.
yes, Lordship, then Lordship, some protection may be provided. I
Not at this stage,
definitely
Lordship.
appear.
It's a huge amount of money, Lordship.
We'll go for the updated one. We won't pass any
Whether,
order in
Lordship,
that.
the
We are not
amount was
rejecting now today.
deposited in my account, or how much amount was deposited in my account?
That is still going on.
There is
The CDR analysis report is here, Lordship. What else
Is
is
there.
required?
The CDR analysis is there only. Anyway, we're not,
And
we're
the
not
bank statement
passing any final order today. We need that report also. That was. Heart Mr. A. Burwa, Ilani Council for Deputy. Heart MSSH for Ilani Additional BP appearing on behalf of Cedric. This case diary has received, but it is submitted by MS Bora that it is updated till 18/3/2026. After hearing the submission made by Lani Council for both says, and on result of the record also, it is seen that the investigation to the extent that regarding the allegation of forged seal and signature of the office of the chief principal conservator of the forest, bracket of WL and BD, bracket closed, and CWL. CWL, again W, Itanagar. Itanagar is Itanagar. No, he didn't. That's not. Was armed to do. Case I received. For signature of seal and signature of so and so is not reported in the case diary, by which it is the accused persons shown themselves to be the owner of 2 male elephants, which are to be transported to the state of Kerala in a temple for a temple for a temple. In view of this, let an updated case diary be called for, and IO is also directed to make a note in that regard if any investigation to that effect is carried on by the IO till date. let the updated case diary be called for. The order may be, the copy of the order may be annexed along with it. You copy of the order, notice, it will be after vacation for prior.
Lordship, protection may be given, then Lordship.
Protection.
Lordship, long
That's why
vacation.
we're not giving any protection to you. 14th, immediately after reopening on 14th, 14th, 7. 14th, 7.
Then 15, Lordship. Then 15,
15th.
Lordship.
Okay.
Lordship, a copy of the order may be.
Yes,
filed.
we'll copy of it.
Highly apply.
Mass of it.
Yes, what is 29?
It's an application for anticipatory.
No, yes, action, I know.
CD was called for.
Steps you have received, I think.
Yes.
Lordship, POXO matter, Lordship, notice to respondent number 2.
Notice was sent.
So
at the-
instruction was sought for, Lordship. That instruction we have not received yet.
CD was called for on last occasions, my lord.
CD we have received.
CD not received, Lordship.
Not received.
Not received.
A short date may be given, my lord.
So anticipatory bail after vacation, Lordship.
Lordship, I mean, it would become infructuous, I mean, if it is post before of vacation, after vacation, Lordship. So, I mean, kindly be taken up on Tuesday, my.
Why, when it
Why
was
it will
filed, why it will become infructuous? When it
that-
was filed? No, why it will become infructuous?
I mean, by this time, they are apprehending arrest, my lord.
What to do? There are many people. How can we
My lord,
tackle down?
kindly, I mean, it's a bogus, I mean, though I'm not going into the merits of the case because POXO is involved, my lord. But as the instructions I have received, the thing has been, I mean, framed the petitioner. So my lord may taken up on Tuesday, my lord. CD may be called. I mean, it's an honest request, my lord.
We cannot fix a date. Well, let it be after 1 week then. It may be because next week will be a motion day, motion week. So there
That is
are
why.
many matters, and that apart, I have some another issue. So now the question is that if you insist, then we can make it not fixing any date after 1 week.
So then it would be difficult to list it before
Then
vacation
what to
because
do? What
I
to
mean, on next.
Now your state is still awaited. Now see, your
Yes.
your notice is still awaited.
Yes, Lordship. But the thing is, my lord, if it is posted for one occasion, Lordship, on 23rd, I mean, if CD comes, Lordship may consider Lordship.
How
Because
you
otherwise it would be difficult for us to list the matter.
Now,
Because
how can we consider?
Lordship,
In the absence of the
If-
respondent, we cannot consider.
in case the respondent appears by that time,
Then
my lord,
again it is the same case.
Lordship,
Again it is same case.
Lordship, it's an.
Because you have taken steps on the na.
Yes,
You
Lordship.
have taken steps. I'm not on that. Heard Mr. A.S. Chaudhary, Dilani Council.
N.A. Majarbuya, my lord.
Huh? Sorry. Oh, M.R. Majar.
N.A. Majarbuya.
N.A. Majarbuya, Dilani Council for the petition. Also have Mr. M.S. So and so. CD not received, and the as per office note dated 10/6/2026, this service is still awaited for the respondent. However, the petition additional PP MS Bora is hereby asked to take instructions in regards to service of notice on the respond number. Also call for the reminder may be issued to call for the case that is the matter.
After you, my lord. After you,
Yes,
kindly,
sir.
my lord. Any date before vacations, my lord.
24/6. We'll
Highly
use in
applied.
other forum.
Highly applied.
Cannot follow all these cases. Last 40?
May please, your lordship.
Yes, what is 46?
46 is a POXO matter, my lord.
MS and
Yes, my lord, my learned friend has appeared.
you are here.
Case 10 is the FIR, my lord. Basically, my lord, the case, my lord, revolves around adolescent love, my lord, as per my instruction, my lord. The girl is allegedly 17 years, but for my instruction, she is 18 or plus 18, my lord. But in the FIR, it is written 17 years. And her parents said while she was sleeping, my lord, in her room, then the boy came and kidnapped. My lord, there are some in the room, my lord, inside, in a house, my lord. Her parents were also there. He went there and kidnapped her, my lord. This is the allegation. This is the allegation, my lord. She is 17 years as per the FIR, my lord. And the boy is also 19 years, my lord. As per my instruction, my lord, there was a love affair between them, my lord. Then she went on her own volition. Then, my lord, the parents, my lord, recovered from her in a melancholy state from the in front of the accused person's house, my lord, and hence this FIR, my lord. Yes. Now, my lord, what is in her
There
statement?
is other allegation of rape and all is also there.
My lord.
No, as per FIR, I'm not
Yes,
saying
yes, my lord. These are but these are written by. I don't know what is her statement, my lord. Now, statement will reveal everything, my lord. But as per my instruction, my lord, there was a love affair. The boy went to the house. Came because someone has to open the door, my lord. Because her parents were also there. Yes, my lord. So, my lord, these are the questions, my lord. Of course, it is a question of trial, my lord. But I'm raising, my lord. But the boy, as per my instruction, both had a love affair. Then she went her own volition. She was recovered. That parents, my lord, lost this case, my lord.
Yes, Mr.
Malat, yes, regarding love affairs, that is there, and she is exactly 17 years. Malat, her date of birth is Malat, 19 February 2009, and FIR is 13 February 2026. Malat, 17 years, 6 days below 17 years, Malat, on the date of occurrence, Malat. And in her Malat, statement, 183, she has implicated forceful, that was switched twice, Malat, not a single, Malat, one, it will also. I'll not peruse the statement of the victim. She is exactly 17 years. There is a certificate, school certificate is there, a Gampura certificate is there, and medical she refused.
Yes.
Anticipatory bail, Malat, and for anticipatory bail, we have a objection, Malat.
Boy is also 19 years, my lord. Boy is 19 years, my lord. And as per my instruction, they had a relationship, my lord. It happens, my lord, adolescent love, my lord. But, my lord, rest I leave it to your lordship, my lord. But boy is 19 years, my lord, and there was a love affair. As per my instruction, my lord, she went on her own volition. But, my lord, now, my lord, putting that boy in jail, my lord, I leave it to your lordship, my lord.
She's
My other friend is also there, my lord.
Am I guessed?
Jail?
Jail,
not, it is a anticipatory, isn't it?
Anticipatory bail.
Yes.
As section 4 of POCSO Act and 3, the 64(1)(137)(2) is there, and specific allegation of rape is there, and implication is in the statement of the victim. And as it is under POCSO, there is allegation. So at this stage, Lordship, anticipatory bail will not lie, Lordship, as per this.
As per?
As per the statement of the victim as well as the FIR allegation is there, Lordship. And 29 of the POCSO Act, there is presumption. So,
no presumption.
Considering all the
will
facts,
come on at the
anticipatory bail,
trial
Lordship.
stage.
Yes, Lordship. And section 4 is under 29. It comes under 29. So presumption is there, Lordship.
No, presumption is in POCSO, presumption is always there,
Yes,
but it is a time of trial only. Why I'm saying whether it is applicable at the stage of bail also.
Yes, Lordship.
I don't think so, but yes, presumption is always there in POCSO. Had Mr. S.M. Abdullah P. Dilanet counsel for the petition. So and so. It is submitted by Mr. Abdullah that the present accused petitioner as well as the victim had the love relationship. And on the day of the incident also she went outside on her own volition, and there was own volition. That apart, no such incident had happened as alleged in the at the time of As per instruction, at the time of incident, the girl was more than 17 years of age. And at the same time, the boy was also 19-year-old, 19, and the petitioner is also of 19 years of age. There was admittedly an adolescent love, and if anything had happened, it was purely unconsensual. The petitioner is, however, ready and willing to extend his cooperation in further investigation of this case if he is granted with some interim protection. Next, Mr. Parasar delayed additional PP his objection and submitted that from the case diary as well as from the her birth certificate, it reveals that she was exactly 17 years, 6 days at the time of incident, on the relevant day of incident. And she implicated the accused petitioner in her statement recorded under Section 183 BNSS. Mr. Of course, Parasar accordingly raised objection and submitted that may not be a fit case to extend the privilege of pre-arrest bail to the petitioner at this stage. MS Chaudhary, the learned amicus, appearing for the respondent number 2, also raised objection and submitted that there is a specific allegation of rape against the present petition, and case is also registered under Section 4 of the POCSO Act. And hence, the petitioner may not be provided with the privilege of pre-arrest bail at this stage. Next, considering the submission made by Learned Counsel for Courts, I have also perused the case diary and the statement made by the victim recorded under Section 183 BNSS. It is a fact that she made some allegations, she brought some allegation against the present petition. However, it also cannot be denied that both the petitioner as well as the victim had love affairs and the love affairs. So considering the materials available in the case diary, the age of the present petitioner, as well as the other circumstances of this case, this court is of opinion that privilege of pre-arrest bail can be granted to the present petitioner with the certain terms and conditions. Okay, will be your pre-arrest bail prayer is allowed.
Like, Madam.
There will be some conditions abide by all the conditions.
I'm grateful, Madam.
Why do you need it without that? Mr. Chaudhary. Mr. Chaudhary, yes. What I'm saying that we have fixed one matter at 2 p.m. That will be hard. At matter 2 p.m. Is already been fixed. One bail matter is left, that will be hard, and then at 2 p.m. one matter is already fixed, it will be hard. Now, what I'm saying that in item number 30, these are connected, some connected matters are there. It is stated as a part hard. I just cannot answer why it is part hard. Part hard. But there was some, so I fixed it at 2 p.m. once. Part hard means I have not passed any order on part hard. Then when I saw that, yes, I can still remember that there was some sort of submission from the both sides that was hard. But not exactly part hard, but I put it at 2 p.m. We'll do after that hearing matter, we'll try to take up the matter, but I don't know one senior counsel. I've also seen a leave note of a senior counsel.
I'm appearing for Mr. Kinshaw is leading this case.
Yes.
Here the charge sheet was filed in the predicate offense and it was discharged. So that has been brought on record. And in terms of the judgment that we are seeking for the
that was been brought on record to an additional.
yes, it is a copy also has been given. So that only that aspect has to be looked into. We will not go into the merits of the case. Now, since the predicate offense has been decided and the charge is there. So we'll show only
okay, then they'll do one thing, we'll take up the one bail matter is there, we'll take up then at 2 we'll start that matter and then we'll come to your matter.
Yes. We'll see that will, if there is some difficulty with that, let the matter reach, once it is called, then we'll.
Okay, we'll see to it. After that only we'll take up this matter. Let me hear first that
There
matter.
are
and then-
admission matters also.
Yes, admission matters are left. There are many admission matters. But one admission matters is fixed at 2. We'll take up that matter and then the other matters are also there. So I do not know. Yeah, I usual question, but because I just asked why, because it was, I saw that it is written as a parter. That's why I only asked Mr. Chaudhary whether it was a parter. So I thought that some sort of, at some length it was hard.
It was heard at line, in fact.
So, but I have not kept it as a parter. Anyway, if it reaches, then we'll hear the matter.
May it please, your lordship. Lordship, I seek some accommodation. Item number 36, lordship.
30?
36. I'm for the petitioner. And for the respondent, Dr. N. Deka and H.S. Kalsi are representing them. I had called them in the morning, but they said they have returned the file. Returned the file to the
Return?
No, we are from the petitioner.
You are the petitioner, yes.
But N. Deka and H.S. Kalsi have returned the file to the respondent. So I couldn't take the so I wanted adjournment for the lordship. Conducting counsel is out of station. 36, sir.
Conducting counsel, who is conducting counsel?
S. Perveen.
S. Parvin is on conducting.
Out of station, yes. 36.
No, but you were saying that Ndeka and
And
SH
they are the opposite side, lordship.
They have already returned.
Yes,
So
returned the
that
file.
is, that instruction is with you.
Yes. And I tried to take the consent. They told me they returned the file already to the respondent. You are for the respondent?
Respondent number 2, lordship.
Respondent number 2.
So you, what is your name?
S day.
S?
Behalf of Ibu Sharma.
Huh?
Yes.
On behalf of?
S day, I have my name.
Okay.
UB
So, lordship, kindly
Sharma.
seek some accommodation from Times, lordship.
So now what he has submitted were Dr. Ndeka and SH Kalsi was there earlier.
Yes.
So they have returned the brief.
They have they are the new council. I
So
just came.
you are the new council.
New council, lordship.
New and guest council. So now he is seeking an adjournment today. Do you have any objection?
Out of station.
Lordship, I have no objection, but madam, we fix a date before vacation.
No, Lord. After 21st.
We cannot.
After 21st, lordship, any date.
Cannot fix any date.
After.
Yes.
After vacation 21st, any date, lordship.
Before vacation, no dates.
Last week will be Sunday.
Yes, no date. No.
Immediately after vacation.
After 21, lordship, because.
After vacation will be fixed.
Any date fixed.
Simple program like consent of 23rd of July.
Lordship.
After vacation.
Lordship. Deeply obliged.
May I please the option? Lordship, item number 14, adjourn for the day.
Okay, we'll see. Not, but I'll take one that. Then a petition PP is submitted by Mr. Das that the service on the respondent number 2 is still awaited. And in view of this, let the matter be listed. You want any fixed date or after vacation?
No, sir. After vacation, any date may be fixed.
27th of July.
Obliged.
Service be awaited till next.
Similar period, lordship, regarding item number 34, lordship. Service
34
report
is,
for the response number 2, lordship.
Still awaited?
Yes, lordship.
Same order, go to get it. 27/7.
7.
May I please the lordship? Lordship, item number 14, adjourn for the day, lordship.
Yes, item number 14
Matter may be fixed on 24 or 25, lordship.
of this month. This month?
14, this one.
Oh, no, not possible. You are for the other side.
Yes. Am I considered?
Adjourn is adjourned to next week. It's not possible.
It is
Otherwise,
after
also it will be a motion week only.
After vacation or any
It
date?
will be after vacation. If you want any date fix, we can fix it. But was there any interim?
Date may be fixed.
Interim was there.
Maintenance matter, your lordship.
Oh, just a maintain. No. But a stay is there or everything is
No,
okay.
your lordship. Already judgment has been passed, your lordship.
Okay. Judgment is passed?
Yes, your lordship. In that maintenance matter, your lordship.
Yes.
For
Okay.
revision, they have passed.
Your MSA Begum.
A
You are-
Khatun.
Huh?
On behalf of A Begum.
You are?
A Khatun.
A Khatun. A Khatun appearing on behalf of A Begum. and also heard MS Esnalton, the learned amicus, appearing for the sole respondent. The request made by MS Khatun, the matter is I2, let the matter be accordingly listed and be dated 24th of July. After vacation, will long day,
Long day.
all construct fine. 21, 21st.
Obliged.
Waiting. Like itu kita pun apa dah? Insya Allah main ini kena boleh bisa. So sorry for us. No puedo. Actually no puedo. What's happening, my dear? This criminal petitions is devoid of merit and stand dismissed. 43, no? Bill hearing at last year. 80. Yes, 18 who is at least. You are on 18.
My second copy was called from, and it is received.
You received?
Received.
And service is also complete that respondent is appearing. Here Lordship, the petitioner who is aged about 23 years, he is in custody Lordship. And admittedly Lordship, there was some love affair with the victim girl Lordship. And mother of the girl lodged the present case. After that, he was arrested Lordship. And in fact, Lordship, in 164 also, she has not alleged that any bad act was committed against the girl. Lordship can state where see the 183 statement of the victim girl.
Victim.
Victim. That no, that section 6 is there, but that is not attracted from her 183 statement. Lordship. So instead of arguing further, Lordship may kindly see that I will. Because she cannot
This
change.
is 183.
No.
Your petitioner's name is?
Abdul Motin Elias Imran.
And what is the stage of the case at
Charge sheet submitted and Lordship, it is an appearance stage, Lordship.
And
One of the
what about your mother's statement you're saying?
Lordship.
You're saying statement of the mother is also recorded? No.
Probably recorded, Lordship. That I do not, I have not seen.
No, you have just submitted that his mother.
The victim's statement is recorded under section 183. She says, Lordship, that no bad act is committed with her, Lordship. So if that is her statement, then Lordship, she cannot change her version in while deposing before the court also. and it will not attract section 6 of the POCSO Act, Lordship. And in fact, when I filed bail application before the trial court, she appeared and this victim, Lordship, submitted that they have no objection if bail is granted.
She said.
Lordship, that page 26 of my petition, Lordship, may I kindly have a look? Page 26. Fifth line from top, Lordship, page 26. The informant and victim have made their appearance and submitted that they have no objection in the bail of the accused. So admittedly, there was some relation, Lordship, and that adolescent boy and girl. Because of that, Lordship, there was some dispute and subsequently affair was lodged. And my learned friend is appearing, probably he can also say what is their stand now, because before trial court, they have said they have no objection. Probably he can say what is their stand now.
Lordship, I am appearing for respondent number 2, Lordship. I am not objecting to the bail clear made by the petitioner. Admittedly, Lordship, there were relationships, Lordship, between the petitioner and the victim girl I am representing, Lordship. Lordship, in this case, Lordship, bail may be granted, Lordship. And I am 16 years old, Lordship.
You are 16 years old?
16 years.
Yes.
So in this case, my lord, searches submitted, my lord. Against this present petitioner, my lord, section 6 also, my lord.
The section 6
also searches submitted, my lord. But going to the, my lord, 183 statement, my lord, section 6 may not come, my lord. A search the to frame, my lord. And other co-accused, my lord, he has been.
Mr. Purva, the learned petitioner, PP appearing on behalf of state respondent, and Mr. M. Ahmed, the learned counsel, appearing for the respondent. This is an application under section so and so in connection.
I'm sorry to interrupt, Lordship. Just one thing, if I may point out, Lordship. Here, Lordship, in the cost title, Lordship, section 137, subclause 2 is not mentioned because in the charge sheet, if your Lordship see, there is page 18. In the petition also, Lordship, page 18. In top portion, Lordship, that 137.2 was strike out and initial was there. And subsequently, also, while perusing the bail rejection order, I have found that court also took cognizance under section 137.2. So that part I missed, Lordship, so I could not mention in cost. Lordship may mention it in the order, Lordship, that section 137.2, Lordship, subclause 2. Page 27,
But
Lordship,
in your cost title, it's not there.
it is not there because they have strike out and initial was there. And now page 27, if your Lordship peruse that rejection order, it is that that 137.2 is mentioned there, Lordship. Page 27. So Lordship may only mention that 137.2, Lordship, in the order.
So and so. Next it will so and so hard. So and so no. Submitted by Mr. Ahmed, the learned counsel for the petition that as the case was from the charge sheet, it is seen that the case was registered under section 61 to 96 oblique 65(1) BNS read with section 6 of the POCSO Act, wherein 137(2) of BNS was deleted within was deleted or was to However, he submitted that while passing the order rejection order by the learned special judge dated 20/04/2026, the it is held that the case is registered under section 61 to 96, 65(1), 137(2) of BNS read with section 6 of the in view of the as this section was deleted from the charge sheet, inadvertently the section 137 2 subsection 2 BNS was not mentioned in the cause list of the present bill application. Next. Mr. Ahmed further submitted that there was an admittedly love relationship between the accused petitioner as well as the victim. And from the statement of the victim also, it reveals that apart from the allegation of kidnapping, there is no other allegation of the penetrative sexual assault to attract Section 6 of the POCSO Act against the present petition. That apart, the case is already charge sheeted, and the case is also charge sheeted, and hence the question of tampering with the evidence is also not the question of tampering of so and so is also does not arise at this stage. However, the petitioner is still ready and willing to appear before the Learned Special Judge on each and every day to be fixed by the court and to contest the case. Next point. Dr. Lepak, he further submitted that there is, as per his instruction, there is talk of settlement is going between the parties, as both the petitioner as well as the victim had dilapidated. Next point, Mr. Burwa, the learned additional people, submitted that though the case is registered, though the case has been charged sheeted under Section 6 of the POCSO Act, but considering the statement made by the victim under Section 193 BNSS, it is seen that there's a probability of the ingredients to attract Section 6 of the POCSO is not there in the statement made by the victim under Section 183 BNSS. However, he submitted that she brought the allegation of kidnapping, etc., against the present petitioner without recording any statement of the victim, the bail payment. Next point, Mr. Ahmed, the learned counsel appearing for the respondent number 2, submitted that as per his instructions, the victim as well as the informant has no objection if the bail prayer for the present petitioner is allowed, and petition is allowed. Rather, there is a talk of compromise of the settlement is going on between. Ahmed wrote submission, first submission, submission before. Mr. Ahmed Agot, counsel for the petitioner, submitted that while rejecting, at the time of initially one bail application was moved before the learned special judge, wherein also both the informant and victim appeared and submitted that they have no objection if bail is granted to the present. Into plan to milai the Next, during the submission made by learning counsel, considering the materials in the case record, as well as considering the fact that the matter has been, the case has been amicably in and other relevant aspects of the case, since that I find it a fit case to extend the privilege of bail to the present petitioner. But so and so. Okay, you are granted with bail. In which paper? Each case?
Special Judge Sribhumi.
Special
Judge
Sribhumi.
POCSO Sribhumi.
Special Judge POCSO Sribhumi. Okay.
How like it?
May it please the laws.
Yes.
My lord, the petitioner before the lawsuits are the mother-in-law and sister-in-law, divorced sister-in-law, and two other persons. I don't know what for they have been made party by the wife while making a petition before the wife means daughter-in-law while making a petition with DB casement. One is a tenant and another is a next door neighbor. My lord, First of all, I beg to draw your lordship attention to the petitions he has filed before the magistrate under the DB Act, my lord, page 47. Your lordship might have got it, page 47, my lord. She is Neha Sharma, wife of Tanvir Ahmed. Tanvir Ahmed is the son of the present petitioner number 1, widow. Tanvir Ahmed, care of Dilip Singh, house number 5, Manipuri Basti, Rehabari, PS Paltan Bazaar. She is staying separately in that house and filed a petition against the mother-in-law, Salina Begum. Mohsina Begum is sister-in-law, that is the divorced daughter of the petitioner number 1, and staying with the mother with her son. Then 2 other persons, one is a tenant, another, and a neighbor, my lord. My lord, page 48, I have shown your lordship her address. She is staying separately in Manipuri Basti from the mother-in-law and others. Page 48, my lord, that the petitioner is a citizen of India, and as such, she is entitled to all the rights, protection, and privileges granted under the Constitution of India and the law framed thereunder. The petitioner has married with Tanvir Ahmed. Tanvir Ahmed is son of the petitioner, present petitioner number 1. Tanvir Ahmed, son of late Najimuddin Ahmed on 207. They got married in 2007 and started living together as husband and wife from 3rd May 2008. So after the marriage, problem arrives from the in-laws family as they do not accept the petitioner as the petitioner is a Hindu girl, as the petitioner started living together with the wife in-laws and started torturing the petitioner. After 1 month of the marriage, as usual, the petitioner's husband went for work and in-laws started quarreling the petitioner without any reason. And they threatened the petitioner that they are going to throw her out of the house. As the petitioner is a Hindu girl, it is relevant to mention herein that the petitioner and her husband has solemnized their marriage, registered marriage at Marriage and Register Office, Kamru, Gauhati, by the register number so-and-so, certificate so-and-so, dated 9/6/2007. They got their marriage registered in the year 2007. Then also in-laws, that is the mother-in-law and father-in-law and sister-in-law used to torture the petitioner physically, mentally, and emotionally. They have beaten the petitioner in the absence of her husband. And when the husband came to whom, they always used to say about the petitioner faults. Many times the petitioner husband also beaten the petitioner very much. Several times the petitioner approached Paltan Bazar police station for lodging the complaints always. They come and request the petitioner and the police officer that they will never repeat such kind of torture against the petitioner. That soon after the petitioner's marriage, the petitioner is suffering violence. The petitioner never understands why the in-laws torture the petitioner so much. Then in-laws, few months started forcing the petitioner's husband leave the petitioner. The language are not that correct, my lord, as it is jihad. They always insist and make the complaint against the petitioner, and in frustration, the petitioner husband beaten many times in the petitioner as them. As per them, the petitioner is a Hindu and married a Muslim person. The petitioner is a kafir. The parents of the petitioner husband do not accept it till date, and he used to assault several times physical and mental torture to the petitioner as well as the husband, the mother-in-law, father-in-law, who divorced and divorcee with them, and with her son always make conspiracy to quarrel with the petitioner. The petitioner is suffering physically as well as mental torture from the marriage till today. They are never allowed to stay with them. The petitioner begs to state that since the husband of the petitioner not complying with their terms to leave the petitioner and her son, they used to torture the petitioner and her husband several times, used to torture them with the help of threatened persons who are the tenant under the petitioner's in-law's house. Many times, Mohib Sheikha and Mohib Hussein, who are the boyfriends of the sister-in-law, threatened the petitioner to leave her husband, otherwise they will kill the petitioner, her son, and her husband. The petitioner begs to state that one Fazil Jalal, who is in a tenant in the petitioner in-law's house, used to assault the petitioner and used to show so and so before the petitioner many times. Even the husband of the petitioner has warned Fazil Jalal for this act. The petitioner is now could not able to bear all such torture. The petitioner and husband was beaten by the in-laws several times. As the father-in-law died, the mother-in-law and the sister-in-law started torturing the petitioner very much. Even the petitioner and her husband started living in a rented house from the beginning. You'll also kindly note this. See, from the beginning, that is 2007, they are living separately in a rented house. Beginning, whenever they visit to their house, the in-laws used to torture the petitioner physically and mentally. It is relevant to mention here in that the petitioner is living in a rent house. You'll also kindly note this. And also they are not leaving them alone. Then also call the husband of the petitioner forcefully, one that the husband leave, this is leave, L-E should be L-E-A-V, leave the petitioner. Not, they are not going to, otherwise they are not going to give the husband, the petitioner, their ancestral property. For that reason, after so many efforts, they failed to just lastly, after having no other alternative, as the in-laws throw them out, they filed a suit before the civil judge. Your lordship kindly note that aspect also. District and Session Judge Kamrup Gauhati, which is pending before the Honorable Court of Additional Session Judge Gauhati. They even forced the petitioner to eat beef. So now it is impossible for the petitioner to bear all such physical and mental torture. The petitioner several times went to Paltan Bazar police station and also, but due to family issue and due to her child, she never taken such step. But now it is important to take an action, as she is not only suffering, the child also suffering, the husband too. It is relevant to mention here in that Babul Ali and his mother, name unknown, Naib Ali and Muhib Ali, Sheikha, Imran Hussain and Sharaf Ali also tortured the petitioner. But these people are outsider minors. Nasab Ali, Muhib Ali, and they are also neighbors of living in the same, here in the house number 12. They threatened the petitioner, they'll kidnap the petitioner's son. But the petitioner begged to state that the accused persons also, with all the above mentioned named persons, are torturing the petitioner whenever they come to stay at her in-law's house. They come to stay in her, that is, they are living separately. And now the petitioner's mental state is not able to bear all such torture. After approaching the several times to the police station, the petitioner not get any help, as the police officer had advised then my lord to come something missing, my lord code, as it is a matter of family. The accused person even used to slang languages to the petitioner. They used the slang languages in the religious. Even one Fazlul Jalal asked to, this is allegation, my lord, every problem, now it is very much out of the control and they are torturing physically and mentally that the petitioner is fully broken down. That few days ago, the accused, next para, my lord, that a few days ago, the accused with the help of some person thrown the petitioner husband to rehab Nurmati Boys Foundation, from where the petitioner went at the rehab, asked her husband, without informing the petitioner, they are forcefully thrown there. From where I talked with them and asked to leave her husband. The petitioner then came to know that the mother of the petitioner husband has given rupees 15,000 to one Tandar Singh to torture the petitioner husband. The petitioner then bring her husband to the home. The petitioner and her child, as well as the husband, is living in afraid and accused persons has given the threaten to kill. This is her prayer before the story, my lord. Then she made a prayer under Domestic Violation Act. This petition, my lord, she filed in the year 2024. And describing the story, they got married in 2007. And in the midst of the reading, I have read out before the lawsuit that her husband also filed a case, my lord. In this connection, I beg to draw the civil suit filed by the husband, Annexure 1, my lord, page 22. It is a title suit number 163 of 2022, filed by Tanvir Ahmed. He is a commerce graduate, my lord, young, energetic son of the only son of the petitioner, present petitioner, who is aged about 62 years plus, my lord, and ailing health. She lost her husband 2-3 years back. Now the mother-in-law and sister, divorced sister, they are living together. And this is the civil suit his husband filed in the year 2000, my lord. And in the petition, she has also mentioned about the suit having filed by her husband, and they are together fighting with the mother-in-law. And the husband, while making only son and only daughter. Petition number 2 before the lawsuit is a divorcee only daughter, and mother-in-law is a widow. Now the husband has filed a case before the civil court claiming family property. The family property, truly speaking, my lord, they have got a small house that is out 15 lessons of land, 3 stories. And I draw your lordship attention. I draw your lordship attention. Out of this 3 story, page 28, my lord, in the civil suit, in the civil to last paragraph, my lord, page 9, page 28, para 9, my lord, that a part of the parcel of the second floor, approximately 500 square feet of the aforesaid building is presently under the occupation of the plaintiff. Plaintiff means the husband of the woman, my lord, her son. It's small 3-story building, a 15 lessons land, there is and this woman, that is the mother-in-law, sister-in-law, they are living on it, my lord. My lord, your lordship, kindly see in the page 29, the civil, in the filing of the plaint, the learned advocate who drafted the plaint, he has calculated the rent getting by the mother, and it comes to, my lord, in the page 29, it comes to rupees 50,500. Out of this 50,500, the woman along with the divorced daughter and the son, who is also matured with the daughter's son, they are living, they are medical expenditure, this thing, that thing. And her husband is the able-bodied son. The woman who has filed the case was not making her husband a party. She is living happily with the husband in a rented house. Rented house means her mother's house. Her mother is outside, she living in Manipuri Basti in a rented house. And this petitioner, Nihar Sharma, she is living with the mother and sometimes visiting the husband who has occupied the second story of the building. It is admitted in the plaint that the husband, Tanvir Ahmed, only son of the woman, has captured the house of the second floor and is staying there. And she also goes sometimes and has to drag out her husband. They quarrel. Husband is a drunkard, my lord. He oftentimes he commits serious suicide, and the people are fed up. Local people, mother-in-law being mother speaking out frustration in a frustrated state, called the police. She was also even given sent to the rehab center for his modification, my lord, and she quarrels with the mother-in-law. Why you are sending my son to the rehab center this thing? So I just like to draw your lordship attention. The husband filed the case in 2020. Only he being the only son. Automatically he gets the major share of the family property. He being the only son and one daughter and mother. Mother gets 1/8 of the share, and among the sister himself, sister gets half and he gets the one. That is a major share of the entire family is to be availed by the son. And in fact, he has filed a case, he is fighting. And then in 2020, he filed a suit. In 2024, after their collaboration and instigation been made by the husband, she has also filed the case of domestic violence against the mother, widowed mother, and a young daughter and sister who is a divorcee living someone with a mother. And that too, after having married in the year, admittedly they got married 2007, and this suit has domestic violence petition has been filed in the year 2024. This is your lawsuit, kindly see. It is absolutely the abuse of the process of law just to harass the woman, my lord. Truly speaking, my lord, if you read the Protection of Women and Domestic Family Violence Act, my lord, a definition, your lordship, in the definition, my lord, domestic relationship. Your lordship may kindly take this book, my lord. Domestic relationship means a relationship between two persons who live or have at any point of time lived together in a shared household when they are related by consanguinity, marriage, or through relationship in the nature of marriage, adoption, or are family members living together as a joint family. Living together as the joint family man. Your lordship may please take this book of mine, man. Monastic. Have you brought this book?
So you want to submit it, what is the domestic relationship?
My lord?
You want to submit it on the domestic relationship?
Domestic relations.
Yes, what is your submit?
Your lordship, kindly the definition, my lord. There, in the definition, it is stated, my lord, living in a family. The last wordings, my lord, kindly see. And admittedly, from the hard petition itself, as I have read out before the lawsuits, my lord, she admitted the marriage of being held in between them in the year 2007. She has been residing in a rented house, admitted. She is residing in a rented house, and the husband has stated in his plaint, as I have drawn your lordship attention, that he has occupied some part of the second floor, about 500 square feet, and the three-story building, total income out of this three-story building around monthly income comes to rupees 50,500. And they are living on this somehow with the big family in Gauhati city itself. She is living in Manipuri Basti and sometimes visiting. In her petition herself, she has stated sometimes she is hobnobbing and visiting her husband as to drag him out. She is quarreling with the mother-in-law when the husband admittedly gets intoxicated out of drinking and being unable to control him. The mother sometimes calls the police, even the agent of rehab centers, as to put him there for his rectification. It is admitted by herself in her petition. My lord, in such a situation, my lord, and she having a separate abode of her since the beginning of her marriage, how she claims to bring out the allegation against the mother and sister-in-law, the widowed mother. It is, in fact, my lord, I have got the information from the petitioner, that is widowed mother, that she have consulted some advocate for filing a case against our son and the daughter-in-law for claiming maintenance of herself. She needs huge medical expenditure, and this amount of house rent is not sufficient at all to maintain herself. In fact, she is in such a need, my lord. Now, the son-in-law, that is son, the wife, son of the wife, husband of the petitioner, the Tamil Nadu, who is a overdranked person, he has arranged that he has filed, one has filed a civil suit, and he is dragging the mother, 63 years old lady, ailing lady, widowed lady, to the civil court every month, and on the other has instigated his wife, who is living separately, and hobnobbing with her, a case of domestic violence. That too with the wild allegations. If we read her petition itself, my lord, see, it is clear admission she is living separately since from the beginning. And she also stated sometimes she visits her husband's place. And in our petition, my lord, we have given empirically the description as to how they are living and torturing each other, my lord. If I beg to draw your lordship attention to the petition, my lord, our petition, paragraph, page 5, my lord. Page 5. The petitioner begs to state that the opposite party, number 1, Neha Sharma, and the only son of the petitioner, number 1, Tanvir Ahmed, got united allegedly as husband and wife in the early part of 2007. It is necessary to mention here that no clear residential background of the opposite party, Neha Sharma, ever disclosed by her nor anywhere known to the petitioner parents. However, as told by the son of petitioner number 1, as he married the wife, Neha Sharma, and her husband, Tanvir Ahmed, they were welcome, and accordingly, Neha Sharma and her husband, Tanvir Ahmed, was living in the same campus with the husband and in-laws. These stay of the opposite party, Neha Sharma and Tanvir Ahmed, that is the husband of the Neha Sharma, with the parents-in-law in the joint mess hardly continued for 1 month. That is in the early 2007 after marriage, they hardly lived for 1 month. Thereafter, they got separated. She went to nearby Manipuri Basti, staying with her. She took a plea that her mother has got only son, and while staying in Manipuri Basti rented out, their son died, and so she was compelled to stay with mother. And her husband was also coming down here, living together, and sometimes went to the mother's place and occupied the second floor of the building. He's overdrunk and quarreling all along with the mother and the neighbor peoples and the tenant. In this way, they are trailing one. So from the description I have given vividly, it is while describing the story behind their relation, and many times, my lord, in the police station, the mother was compelled to lodge complaints against the son because of his intoxication and quarrel with others. The police also well informed. It is admitted in her petition itself by the wife, my lord, that I have read out for the lawsuit. Poltramadar police is also aware of the background of her husband, my lord. So this is my respectful submission before the losses, my lord. If it is absolutely agreed to the process of court. In this aspect, I beg to draw your lordship attention, the Honorable FS, to judgment of the Affairs Court. Apart from the judgment of State of Haryana and Bhajalal and others, my lord, which my learned friends are also stated in her petition. So this one of the judgment I beg to draw your lordship attention. 2022-6. দুইটা গেছে তাতে যখন গেছে নাকি My lord, your lordship may be pleased to see paragraph 16 and 18, my lord. The court should be careful in proceeding against the distant relatives in crimes pertaining to the matrimonial dispute and dowry debts. The relatives of the husband should not be roped in on the basis of the omnibus allegation unless specific instances of their involvement in the crime are made out. Then, my lord, in paragraph 18, your lordship, coming to the facts of the case, upon a perusal of the contents of FIR 1/4/1990, it is revealed that several allegations are leveled against the appellant. The complainant alleged that all the accused harassed her mentally and threatened her of terminating her pregnancy. Furthermore, no specific and distinct allegations have been made against either of the appellants, either that is, none of the appellants have been attributed any specific role in furtherance of the several allegations made against them. This simply leads to a situation wherein one fails to ascertain the role played by each other, each accused in furtherance of the offense. The allegations are therefore general and omnibus and can at best be said to have been made out of account of the several skirmishes. Insofar as the husband is concerned, since he has not appealed against the order of the High Court, we have not examined any veracity of allegation made against it. However, as far as the appellants are concerned, the allegation made against them, being general or omnibus, do not warrant prosecution. She did not make her husband a party man. He is living with the husband. How happily and quarreling by visiting the house of the husband, she is quarreling with the other tenants. It is reflected from her petition itself, and also we have described vividly in our petition how they are behaving. So this is one part of the matter. Another judgment, I beg to draw your lordship attention to This is a judgment of 2010, 7 SCC, my lord. Here I beg to draw your attention to paragraph 13 to 26, my lord. Paragraph 13 to 26. Paragraph 13 is page 671, my lord. Last part, the one. The main question which falls for consideration in this case is whether the High Court was justified in not exercising its inherent powers under Section 482 of the Code of Criminal Procedure in the facts and circumstances of the case. This court in a number of cases has laid down the scope and ambit of court's power under Section 482 PRPC. Every High Court has inherent power to act ex debito justicia, to do real and substantial justice for the administration of which alone it exists, or to prevent the abuse of the process of court. Inherent power under Section 482 Criminal Procedure Code can be exercised to give effect to an order under the court, to prevent the abuse of process of court, and to otherwise secure the ends of justice. So absolutely it is a case I have read out before the lawsuit, the abuse of the process of the court. She, having married in the 2007, has filed a case in 2024, and preceding that, her husband has filed a case in 2020. Now the husband is instigated and she has filed a case, a joint filed by husband herself, again the old mother-in-law, who is in a difficult position to live herself out of the petty income of the family. She cannot maintain herself even, my lord, and she is advised to file a case against the daughter-in-law and her son. Her husband is a commerce graduate in the year 2000, before 2007, and she is also highly educated. And as per my latest information, she is working with a chartered accountant as a writer, quite competent, my lord. Now they are ready about to capture the family. In fact, she has already filed a civil, her husband has filed a civil suit. They will get a relief out of the civil court. And they are entitled, the husband is the only son, and a daughter and widowed mother. Mother gets 1/8. Your loss is aware of the Mohammedan rule of distribution of the family, but the mother gets only 1/8 of the family. And among the son and daughter, she is the only son, he gets the medal. There is no case of fighting in the civil, automatically gets. Over and above, they are not cooperating, they are living separately.
Okay, you have repeated this.
So my this is humble submission before the lawsuit, my lord. In this judgment, my lord, I have placed para 15, 16, 18, and 19. 21, 22, 23, my lord. Your losses, this is a long reading. And in paragraph 24, for your losses information, my lord, that is reported the landmark judgment of the affairs court, that is State of Haryana Bhajan Lal. My learned friends also referred in a case petition I have seen, my lord. It is also the conditions are also provided there, my lord, as to how for futility of the matter, the interference of the court is required for quashing the frivolous petition filed by some person for harassment of the people, my lord. So this is my limited submission before a law.
May it please, Your Lordship. Lordship, have already got the factual aspect of the DV matter, my lord. I will not trouble Your Lordship with repeating the same, my lord. What happened, my lord, after the marriage, my lord, she was not accepted in the family because of this intercaste religion, my lord. And they have already also quarreled with her. They have beaten her, my lord. They have used abusive words, my lord. And they have tortured her to every aspect, my lord, emotionally, physically, mentally, my lord. And what happened, my lord, they have also taken the help of one of the tenant, which I have specifically mentioned his name. His name is Faizul Zalal, and one is the neighbor, Babul Ali, my lord. We have specifically named them, and we have made them party. because of the fact that they were also involved upon the instigation of the mother-in-law and the sister-in-law, my lord. They were also troubling the respondent, my lord. And they have also done some obscene act in front of the respondent, my lord. And because of which, my lord, she was very disturbed, my lord. And for which, my lord, her husband also have warned him because of that, my lord.
But whether there is any domestic relationship with this neighbor as well as the tenant, can it be called as any domestic relationship?
Because of this, my lord, physical harassment and there were sexual.
There are other options
attempt.
for her also.
Lordship.
If such kind of thing is abusive word or some obscene act is done by them, suppose.
Yes, ma'am.
There were, but they cannot come under any domestic relationship.
Yes, because
As per the definition.
but they were one of them is a tenant, so they're residing beside them. So whatsoever, my lord, but they were also they have done it because upon the instigation of the family members, my lord, in-laws. That is why we have made them a party, my lord. And what has happened, my lord? There were also threatenings of kidnapping my son, my lord, the respondent's son, and they have also the mother-in-law have and father-in-law. They have never accepted the respondent's son to be the legitimate son as their grandson, my lord. That is the thing, my lord. And what has happened, my lord? Soon after the respondent's brother died, my lord. That is in the year 2012, my lord. Thereafter, my lord, she has been separated. She is totally living with her mother, my lord, in Manipuri Basti, my lord. Before that, my lord, she was staying with the in-laws, my lord. But and she still, my lord, till the present date, my lord, she keeps on coming and going, my lord, because her husband is still staying with the in the matrimonial house, my lord. And this regarding, my lord, the pre-occupation of the property, as they have stated in the civil suit, my lord. Pre-occupation, my lord, as they have said, as per paragraph 9, my lord, of the petition of the plaintiff, my lord. He was already in that building, my lord. He was already staying in that room, my lord, prior to his marriage, my lord. And after my marriage, my lord, I have been staying together with the mother-in-law, and the sister-in-law also was there, my lord. I stayed there for some days, and thereafter, because of all these incidents, my lord, I had to come back. And also after the death of my brother, that is after in the year 2012. And although, my lord, there has been some mistakes in the petition, in the DV petition, my lord, as has been typographical errors are there, my lord, has been from the conducting council there, my lord. We have been recently appointed. So it was written from beginning, but it was not from the beginning, my lord. Thereafter, my lord. So, and lordship, I would like to come to the affidavit in opposition now, my lord. Filed by me, my lord.
Yes. Which page?
Yes. The page number, my lord, will come to the first annexure at page
Paragraph
60.
53.
Yes,
Page
page number
53.
60 is the annexure 1. This is a type version, my lord. The relevant portion is at, my lord, comes from 65, page number 65. After the DB case was instituted, my lord, against them, my lord, the respondent appeared before the CDPO, protection officer, my lord, and she has reported the incidents of domestic violence upon her. And in the report, my lord, it has been recorded, my lord, recorded incidents of assault on 30/5/2019 on the aggrieved person and her husband by Moshina Begum, so and so. Attempt to murder by Babul Ali, Mohib Ali, Pranjal Band on aggrieved person and her husband. Applications were submitted at Paltan Bazar PS. Several incidents of physical violence have been inflicted on the aggrieved person by the respondents, leading to severe injuries. Next page, my lord, page number 66. Attempted sexual assault on the aggrieved person by the tenants and neighbors of Salina Begum by the name of Babul Ali and Fezul Zala on the directions of Soon after the marriage, verbal and emotional abuse started on the aggrieved person led by the in-laws. As per aggrieved statement, she was abused because of their religion marriage. So and so happened. In-laws refused to accept their grandchildren as their legitimate child. And next page, my lord, at 67, the respondents Salina Begum and Moshina Begum refused to give economic rights and property rights to the agreed person and her husband, my lord. And there were also verbal abuses for dowry-related demands. So this is the report that has been submitted by the protection officer, my lord, before the learned court below, my lord. Thereafter, my lord, the husband of the respondent has also approached the Paltan Bazar PS, my lord, on 29/5/2019 and 30/5/2019, my lord. I have annexed herein the FIRs, my lord, at Annexure 2. Page 74 is the FIR, my lord. May kindly come to. To the officer in charge, so and so. I, Tanvir Ahmed, son of Nazimuddin Ahmed, wish to submit that I want to inform about your matter. For the past 10 years, my parents and sister, who has been living with us for the past 9 years, after leaving her husband, have been behaving badly with me and my family. They have also been mistreating my wife on so and so in the afternoon. A quarrel started at home over a small matter. When I tried to intervene and make her understand, she misbehaved with me. Since my wife is a Hindu girl, she has been abused to, she has also abused her using caste related remarks and forced her to leave the house. I have recordings of the incidents. My sister, Moshina Begum, my mother, so and father, so has been harassing me physically, mentally, and financially for many years, particularly since my married sister returned to the house, to her own house, madam. Today, I am submitting this application for protection of my life and my wife's safety, so that in the future, my parents and sister do not harass me with false allegations. The reason for submitting this application is that in the future, no kind of violence and misconduct should be carried out against us, either inside or outside the premises by any person. My sister has some connections with certain dishonest persons, and I fear that those persons might harm or harass me, since I'm the only son. So this is the FIR matter. Similar FIR has also been filed on 35, my lord. Similar incidents, my lord, because they were torturing at that time so much that I have to, my husband has to go and repeatedly give FIRs against him. This is a fight between the son and the mother, my lord. And the civil suit they are claiming, my lord, it is between the son and the, I am not involved, my lord. The present respondent is not involved. And lordship, the rented house, I'm also staying in the rented house with my mother, my lord. And my husband also keeps coming, and we do not have any personal, any grudges, only that, my lord, they have been, I cannot move to my matrimonial house now, my lord. That is my regard. And lordship, also they have asked my husband to part ways with me. When he denied the same, my lord, then he was refrained from his rightful claims, my lord, over his ancestral property. So this is the thing, my lord. Also, I would also lastly, why this DV case has been instituted in the year 2024, my lord. What has happened, my lord? It may kindly come to their petition, criminal petition at page paragraph number 13, my lord. Page 12, paragraph 13, my lord. That the petitioners further back to state that in the month of April 2024, little before filing of the DV petition by Neha Sharma, her husband Tanvir Ahmed created a notorious situation in the house of the petitioner, being an intoxicated condition, rebuking, assaulting, etc. in the house of the petitioners, because of which we are unable to control Tanvir Ahmed because of intoxicated mood and behavior. She was compelled to request authorities of the rehab located in Mati to come and take the critical patient. So, my lord, why this DV has been instituted in 2024? Because of the fact that without informing the respondent, my lord, they have sent my husband to the rehab, my lord, because of intoxication mood, my lord. So that is their allegation, my lord. So, so I have been tortured to the extent I have to run to get my husband from the rehab. And on the very day itself, he was been taken back from the rehab, my lord, because upon my insistence, my lord. So these are the troubles, my lord, they are making. That is why it was unable to stay with the in-laws, my lord. So I have instituted a domestic violence matter, my lord. And I pray that this matter, my lord, the DV matter is at its very initial stage at this time, my lord. And the petition is, my lord, is pending for interim relief before the learned trial court below, my lord.
Only one
So,
basis
and-
you have paid for interim relief.
Yes,
What
ma'am.
interim relief?
No, my lord.
What interim relief?
Yes, I have paid for protection, my lord, under section. Protection under section 18, 19, 20, 22 of the Domestic Violence Act, my lord. So this is a DV matter I have instituted for protection, my lord.
And then?
Then, my lord, since a prima facie case has been made out, my lord, by the instant respondent. So, my lord, also they have filed WS.
One is for protection, and what is the other interim relief? Monetary
Relief is, my lord, pending disposal, there may be grant interim order and grant an amount of rupees 50,000 per month as a monetary relief in favor of aggrieved person as well as her son under section 23 of the Protection of Women's Act.
So you're seeking monetary relief against your mother-in-law.
Yes. That is, lordship, there has to be some amendments made to the DV matter, my lord. That is true, my lord, because we have not filed this. It was before filed by another council, my lord. Some amendments we would like to make in this. We'll pray before the learned trial court below, my lord, to make some amendments. But other than that, this super was instituted after that incident, my lord, as I have already stated. And they had the respondent has prima facie made out a case, my lord.
Do you think that consultation with you was necessary before sending him to rehab?
At least I may be informed, my lord, because I'm a wife and I've been living with my husband. So when he was in the residence of in my matrimonial house, my lord, at least I should be informed that he was creating a scene or something before sending him to rehab, my lord. So that is my contention. And they have since they have contested the case before the court below, my lord, and they have filed their WS there. So, my lord, I pray that they will get ample opportunity to present their pleas and grievances before the court below, my lord. So, and they are contesting the matter. They have filed WS, and the next date is fixed on 30 July, my lord, for NO. For evidence, my lord. So nothing has been done till date, my lord. And because of the pendency of this criminal petition, also there has been some delays, my lord, in proceeding with the DV matter, my lord. So I pray that, my lord, this
Was there any stay? Stay was not there, I think.
No, my lord. But still, it was kept for NO for few dates, and now it has been placed for evidence, my lord. And that is my humble prayer, my lord, that this criminal petition may not be is not maintainable and liable to be dismissed at this stage, my lord. So because it is the initial stage, my lord. So and the learned court below will be the trial court will be the appropriate forum, my lord, to dispose of the matter, considering all the pleas of the parties, my lord. So I'd like to also place one judgment passed by your lordships, where your lordship, although the facts are a bit different, it was the DV case was instituted against the husband, and here we have instituted for the mother-in-law and sister-in-law. But the fact remains that this was also, my lord, I am praying for similar relief and similar findings and observations being made in this, my lord, judgment, my lord, passed by your lordship. The relevant portion starts from para 10, my lord. I'll give you a copy. Right. So at paragraph 10, my lord, so and so submits that this is not the appropriate stage of filing a petition to quash the entire proceeding. The petition for interim relief is still pending before the learned trial court, and the petitioner can submit all the evidences and raise the relevant issues at the time of hearing of the interim relief application filed by the respondent number 2, my lord. Therefore, the validity of the petition for interim relief can be challenged before appropriate forum. Further submits that the petitioner has already taken plea in the WS filed before the learned trial court, which may be considered by the trial court during the time of hearing. The petitioner will get ample opportunity to oppose the application and present his arguments before the learned trial court below. So these are the submissions made, and court has rightfully observed, my lord, that since the matter is at its initial stage, and also they have contested, participated in that matter, and evidence till now has not been done, evidence of the parties, my lord. So I pray before your lordship that petition may be dismissed at this stage.
The facts of the case my learned friend has narrated is not exactly with the case I have drawn your lordship attention to the fact of figure. They are living since 2007 separate in a different abode. Husband has occupied one floor of the house.
Yeah, you don't repeat this. You have already.
Yeah. Completely separate facts and figure, my lord. And my learned friend has also drawn your lordship attention to the cases filed before the police station. These cases filed by the other people quarreling. It is a criminal jurisdiction, my lord. These are to be charge sheeted by the police. Police has to investigate the matter. These things he cannot bring before your lawsuits, these allegations, my lord, in a domestic violence case. It is absolutely unfounded, my lord.
We do. There was submission here about good one. And I'll record your submission and raise part deliver the order. No? Okay, hard, Mr. We are on 15. MH Madhavia, granted counsel for the petition. Also heard MS
B. Bora.
B. Bora, the learned counsel, appearing for the respond number 1, and Sage Bora, the learned additional PP. This is an application under section 528 of BNS spring for quashment of the proceeding of PV case number 127 of 2020, pending in the court of GMFC Kamrup M, Gauhati, which has been filed by the respondent number 1, respondent number 1. Next, submitted by Mr. Majarhuyan, that the respondent, the respondent number 1 had instituted the case against the present petitioners 1, 2, 3, and 4 with some false and concocted allegation of mental and physical torture. The petitioner number 1 and 2 are the mother-in-law and sister-in-law, the widowed mother-in-law and divorced sister-in-law of the respondent number 1, and the respondent number 3 and 4 are the neighbors and are the are are the tenant and the neighbor of the other tenant and neighbor of the respondent number 1 and oh no, sorry, petitioner number 1. He submitted that day from the DB of the complaint case, DB case. It is evident that the marriage took place in the year 2007, and the present the DB case is instituted only in the year 2024. From it is a fact, admitted fact that the marriage between the son of the petitioner number 1 and the respondent number 1 was an intercaste religion marriage, wherein the petitioner, so respondent number 1 is a follower of Hindu religion, and the petitioner and the son of the petitioner number 1 is a follower of Muslim religion. From the, he further submitted that from the though some allegations of mental and physical tortures has been brought in the petition against her and as well as her husband, but from the statement made in the DB petition itself, it is seen that they are living separately in a rented premises in Manipur University, and has no living relation and has no domestic relationship with the present petitioner number 1, 2, 3, and 4. First, the petition, full stop, next point. Mr. Majavia further submitted that as per section 2F of the DB Act, as per definition of section 2F of the DB Act, the domestic relationship this domestic relationship inverted comma means a relationship between two persons who live or have, comma, at any point of time, comma, live together in a shared household, comma, when they are related by consanguinity, comma, marriage, or through a relationship in the nature of marriage, comma, adoption, or other family members living together as a joint family. But here in the instant case, it is very evident that respondent number, petition number 3 and 4 has had never any domestic relationship with the respondent number 1, and they being the neighbor, but being the neighbor relationship and so and so, and they only made party in this case with a view to harass them, as they are the tenant as well as neighbor of the respondent, petition number 1 and 2. Further, it is seen that from the statement made by the petition, on a statement made by the respondent number 1 in her domestic complaint, domestic petition, DB petition, DB case, it is seen that they are living separately living separately in a rented premises, and they have no domestic relationship with even with the respondent, petition number 1 and 2, since their relationship, since their marriage. However, he submitted that till 1 month of their marriage, they were living in same household, but thereafter they got separated and staying in the rented premises at Manipur University, having no relationship with the petitioners. Next one. Mr. Majapia further submitted that as per the husband of the petitioner is husband of the respondent number 1 is the only son of the petitioner number 1 and who is also occupying a shared household, who is also occupying some portion in their premises, but in spite of his occupation, he filed a civil suit claiming right over the property only with a view to harass the petition number 1 and 2, the widowed motherhood as well as his sister. Further, on the instigation of the husband of the petitioner, husband of the respondent number 1 only, she instituted the case of domestic violence against the petitioners without having any reasons or with some false and concocted allegations, which is nothing but the process abuse of the process of the court. Further, he submitted that the husband of the respondent number 1 is a habitual drunkard, and he used to create a scene after is a scene very oftenly in the area, and for which the petitioner number 1 had to admit him in a rehab center only for his recovery. But considering, with that view also, but with the allegation, the respondent number 1 also brought some allegation against the petitioner number 1, and on that view also the DV case has been instituted against the present petitions. In one hand, the husband of the petitioner is harassing the husband of the respondent number 1 is harassing the petitioner number 1 and 2 by filing a civil suit claiming right over the property, and on the other hand, the respondent number 1 has also lodged this false and concocted case with the allegation of domestic violence, with the allegation of mental and physical torture, only with a view to harass the petition number 1 and 2, along with the petition number 3 and 4, who are no way related or involved in the LS problems. Mr. Majabi also relied on decision of Supreme Court reported in 2022 6 SCC 599 and basically emphasized on para 16 and 18 of the said judgment, wherein it is observed by the apex court that that without any specific wherein the petition for quashing was allowed, which was based on some general and omnibus allegations without any specific mention about the offense of the offense committed by the appellants, by the accused appellant, by accused personally liquidable. Here in the instant case also, it is seen that some general allegations has been brought against the petitioner without any specific mention, without describing any specific incident. However, some incident of uh, uh, outraging of the modesty and uttering of obscene words, etc., has been brought against the petitioner number 3 and 4, specifically in the petition. She also relied another decision of the Apex Court reported in 2010 7 SCC page 667 and relied on para 13 to 26 of the state judgment. State judgment. When also it has been observed that code would be justified to pause any proceeding if it finds that it amounts to abuse of the process of the court or quashing of this proceeding would otherwise serve the ends of justice. The section at the para 14. Fourteen, 21. Two. And 26. Read that. Ms. Bora, the learned counsel body, respondent number 1, submitted in this regard that that since her marriage, the respondent number 1 is subjected to mental and physical torture as she belongs to another religion, another religion. Apart from torturing the petitioner number 1 and 2, who was the mother-in-law and sister-in-law of the respondent number 1, used to inflict mental and physical torture harm, and with the help of the other two petitioners, that is the petitioner number 3 and 4, who are the tenant and neighbor of the petitioner number 1, also used to torture her and even harassing her by making some bad remarks and by and trying to outrage her modesty, for which she also had to institute case against those petition number 3 and 4. It is after her marriage with the son of the petitioner number 1, she used to live in the same house, sharing the same. He was sharing the same household with the petitioner number 1 and 2. But after death of her brother in the year 2012, she had to she had to stay with her mother in a rented premises at Manipuri Basti. But her husband used to stay in her matrimonial house, and for that reason also she used to come to her matrimonial house for her sake of her husband. But whenever she came and stay in the matrimonial house, all the petitioners used to inflict mental and physical torture on her. Stop. Next, she further submitted that the husband of the petitioner, respondent number 1, also lodged 2 FIRs in the police station because of the harassment and harassment caused by the petitioner number 1 and 2, 1 and 2 in the police station. She further submitted that she was never informed when her husband was intentionally took in the rehab center for admission, and on the day itself, on the same day, somehow she managed to get release her husband from the rehab center, which also caused very mental agony and pressure to the, which also caused tremendous mental pressure to the present respondent number 1.
Lordship, I'm sorry to interrupt. That incident may be noted that it happened in the month of April 2024. madam.
April 2000.
Yes, madam. That has been stated by them in the petition, madam.
April 2024. The further statement that she make her statement was recorded by the protection officer, and accordingly report is submitted, wherefrom it has been held that there's a prime facie materials to institute a case or to take cognizance against all the petitioners under the Domestic Violence Act. She further submitted that the case is at the very initial stage of stage, and no evidence is recorded till date, and thus the petitioner will get ample opportunity to oppose to make their defense at the time of the hearing.
Yes.
And hence at the hearing, and hence considering the prime facie materials against the present petitioner, there may not be it is not at all efficacious to pass any order of washing by invoking the power under section 528 of the NSS. She further submitted that she prayed for protection as well as monetary relief under the CTV. MS Vora also that decision of this High Court. This High Court passed in the order in criminal petition number 307 of 2022, wherein also the petition for quashing was dismissed, considering the initial stage of the case, and also we reviewed that the petitioner will get ample opportunity to contest the case as to make their proper defense and to take their profits. So, just recorded your submission. We'll pass the order delivery of order. We are keeping it on 23rd of this month.
Much obliged. ma'am.
Lordship may also note that the husband of the petitioner is still staying with the mother-in-law. Still, ma'am.
Oh, I have written down that
Yes.
one part is occupying by him.
Yes. I'm deeply obliged.
State is also there. I think.
order this order to senior
You look at this here.
May I please, your lordship?
Oh, this is state is also here, na? আমার স্টেট প্রোডাক্ট বা নিজে দিয়ে দিচ্ছে।
May I submit, Lordship?
Yes, yes.
And this criminal petition is filed, Lordship, for posting of an order dated, Lordship, 19/1/26, page 15, Lordship.
19/1/26.
Page 15.
Challenge the order.
Order, Lordship. May I read this order?
Yes. Page.
Page
number.
15, 15.
15.
Case record is taken up in my file. Peruse the petition along with affidavit filed by the I1 Srimati Khairunessa, wife of Zakir Hussain, daughter of Sri Abdul Latif, resident of so and so. Hard learned advocate for a first party at length. It is stated by the first party that she was married to second party in accordance with.
Page is not there.
Lordship,
You're saying which page? Page?
15,
15,
Lordship. 1. Annex 1.
Acha, so it's a wrong. Okay, and anyway, yes.
It is stated by first party that she was married to second party in accordance with Islamic rights and rituals about 11-12 years back, and out of their well-loved 3 children were born, namely Magdiz Alam, presently aged about 9 years, 9 months, Sumia Begum, presently aged about 6 years, 2 months, Mehboob Alam, presently aged about 5 years. It is alleged that since after the marriage, the first party has been tortured by the second party, both mentally and physically on demand of dowry, etc. It is also alleged that 1/11/24, the second party abandoned the first party and left the house along with their minor children. It is further alleged that the second party married another woman and is presently staying along with his second wife and the 3 minor children at the address mentioned above. The second party, being the mother, is now worried about their minor children and alleges that her minor children are ill-fed, ill-treated, and deprived of the basic necessities of life. The first party further alleges the second party was wrongfully confined her minor children and whose lives are insecure. The first party therefore prays for recovery of their minor children from the house of the second party and other probable places. From the above, I am the opinion the activity of second party is an offense and attract provision of section 100 BNSS, previously 97 CRPC. As such, I am satisfied to draw up a proceeding under section 100 BNSS and direct OC of the concerned police station to search the house of the second party and other probable places for recovery of Magdiz Alam, presently aged about 9 years, 9 months, Sumia Begum, presently aged about 6 years, 2 months, and Mehboob Alam, presently aged about 5 years. And on recovery give Zimma of the minor children to the first party petitioner, who is also the mother of the children, with an intimation to this court on observing all formalities on or before a date fixed. Issue a search warrant accordingly, inform all concerned, date fixed on 2/2/26. This is the case, Lordship. But subsequently, Lordship, at page 9, Lordship, I've stated paragraph 11. Page 9, paragraph 11. The petitioner begs to say that the case filed by the respondent number 2 is now become infructuous, as because custody of minor children has already been handed over to the respondent number 2 on 21/26. As the petitioner hereby prepared this petition, as such, the petitioner hereby prepared this petition for quashing the entire criminal proceeding of 30/26 pending in the court of Rocking Burua, Additional Magistrate Kasar Silchar, on the following grounds, among others. I have already handed over custody of the minor children to my first wife, Lordship. And in fact, Lordship, I have solemnized the second marriage, Lordship, for the betterment of the children, Lordship.
Wow.
For the betterment of the children, because children are minor, Lordship. So I have solemnized the second marriage, Lordship.
How can you marry?
And Lordship,
Total
and you see, the first wife, she eloped with my driver, Lordship. She eloped with her driver, Lordship.
Oh,
and leaving behind these minor children with me.
Oh, she had already eloped.
Yes. Eloped.
Oh, acha.
No, Lordship.
So why is the proceeding? Proceeding is under which section actually? Only 100.
Lordship? 100 BNSS. Yes, Lordship.
Interlocutory order, Lordship. Only guardianship, Lordship. Children are now with the mother, Lordship, the respondent wife, Lordship. And he has got, petitioner has got second marriage, Lordship, for which dispute has been started. And now make serious allegations in the writ petition against the, in the present petition, Lordship, against the wife, Lordship. She is the helpless, destitute lady. And this petition is not at all maintainable, Lordship. Because, and at that apart, Lordship, he has also filed an application on same line, Lordship, where he has annexed, making some allegation prior to that, Lordship.
No, just
Subsequently.
complete, let him later, Mr.
Lordship.
Sharma become. No, now question is that the case, which is the case? Case is this is the case. 100 only.
Lordship, because search warrant is being issued and 100 BNSS, what
So
is the
is there
100?
any other allegation or case was registered or only this is the case? Where is the case
Lordship,
record? Case record is there?
Other allegations are there, Lordship. There is undoubtedly there is other allegations, but those allegations are
No,
false and concocted.
what is the case number? Case number is 30
Lordship,
of the
30 of 26. In case of Lordship, so far as
case number is
30 of 26.
30 of 26.
Mm.
Is cognizance was recorded? Is there any, what is this? It is only under section 100.
100, Lordship.
Achha, under
Because
section 100.
what
na?
is section 100, Lordship? Kindly see 100 BNSS.
Hmm.
Kindly see. Search for person wrongfully confined. But-
Yes, it.
If any district magistrate, subdivision magistrate, or magistrate of the
Let's
first
tell
class.
us one thing, Mr.
Okay.
Sharma. Now you have submitted that this
Only question is the custody law.
100 case was registered, whatever.
Okay.
Now search warrant was issued, but you have already handed over the three
Okay.
children to
That's
her.
it. That's it.
So in view of this, is there any case now revive? Any case is there? Or
That is there is no case
Now-
you have, Lordship, because 100 BNS is what is 100 BNS? It is
Yes, only
custody of
for-
minor children, and custody was already handed over to my learned friend respondent, the first wife. So what remains, Lordship? Can we see?
Why?
So that is why we are coming against the
but
question of this particular.
just tell us one thing.
Lordship.
Next date was fixed on 2/2/2026,
Lordship.
and thereafter what had happened?
There,
Now what is the stage of the case? Is there any order? What is the stage?
there,
Because we have to see is nothing is there. You have submitted that, handed over. This is the only order you have challenged. Now what is the present status of the case? Is there any?
for the TCR was also called for, Lordship, in this case.
TCR is any? Is TCR have received?
TCR was called
we
for.
have not received any. TCR was called for.
Call for, Lordship.
TCR was called for.
Yes.
Now we are
There is
not
aware,
at the
Lordship.
stage to say anything. Now, if
Okay.
suppose case is registered only 100,
100.
then as per from your submission, it seems that there's no cases
Nothing-
now at
nothing
present.
remains, Lordship. Yes.
So it may be a case for quashing. But
Quashing.
what about these stages?
Stages.
Because case was the
For that
for
stage,
information of
Lordship,
the
actually,
report of the search warrant
we
was
have no
fixed on
instruction. In fact,
26. And
Lordship,
what about the 2/2/26, or is there any other order? What is the situation stage? What is the case now?
Yes, Lordship. Actually,
Then
that is
to-
why Lordship
cannot-
TCR was called for, but that was not received. If TCR, if Lordship going to the TCR, Lordship will aware. But we have no,
Do you know about
just
that?
no information regarding this.
You're not aware of.
But my learned brother is aware, Lordship, that custody was given.
Not he has already.
But subsequently, what has happened, Lordship, I have no instruction on such. And let my learned
So we are not in a position to say anything in this case.
Lordship.
If suppose there may be a subsequent order also
Lordship.
passed by the trial court, because 100 is already there, and it is I mean this
Right.
recovery is already there. So
Okay.
in that case, there may not be further trial may not be required. But I don't know. We don't know what is the stage. That is required.
They wait for the TCR.
Obviously, we have to. Otherwise, see now there is no such case. Here, notice there, office notice there. Just a second. It's not received. That much only it's there. That apart, was there any case diary? Case diary was not there, I think.
I think in their said order, Lordship, page 15, last, the OC Kaline Police Station for information and necessary action in the light of the above order and report compliance.
Yes. There OC was direction was there for report of compliance. You
But,
made a report.
but after that order, Lordship 19-1 to the, it was fixed on 2/2/26.
Yes, 2/2/26.
But We have no, but my learned friend have to note that progress, subsequent position, lordship.
Subsequent development, subsequent order.
Wait for the
status.
TCL lordship, place the fix, then may fix after vacation. TCL will reveal everything.
Yeah, obviously.
No.
Because allegation, counter allegations is from other side is also there.
Main cracks, lordship may can go to the main cracks. Why this order has been passed?
Yes,
100 BNSS. Custody of the money,
After
and that
getting
was
3
complied.
children, lordship,
Lordship,
my
I have
learned
already
friend
submitted.
petitioner has got married to another lady, lordship, by giving herself
That is a
side, lordship.
lordship kindly see.
This is the thing.
See
lordship.
that
Without saying
respondent
anything,
number-
lordship, he is coming with this squashing,
No,
lordship, just to, because there is a constant thread in the petition, she has mentioned in her petition, under section 100, lordship, everything was there. So I don't know about the subsequent progress of the case, lordship.
Yes, that
Let
is-
the information may come after petition and it is subject to convenience.
Lordship kindly say the allegations, counter allegations are there, but cracks of the matter is 100 BNSS and that is has already been complied. And secondly, we have my learned friends,
But that
friends.
is complied with, it
So-
seems that
so-
he is also admitted
Agree,
that
agree.
now children
Learned
are
friend
with
has
him.
submitted that
Children
there-
are with the mother, lordship. the
lots of
respondent,
allegations are there.
but she is not getting anything, no maintenance.
Why,
nothing.
Lordship, why these allegations?
Just to avoid these things, he came here, lordship. Husband is approaching this honorable court, lordship, without paying not a single penny to
Maintenance
the
will
three
be
children.
decided by the trial court.
Yes,
Why-
maybe, but
decided by, and
Why they are after all-
why I married for the second?
let
I
this
made
matter
for
may
the
come after
second.
vacation, everything.
Because
will
she
clear.
eloped with some other person to Bangalore and he telephonically informed me that I have come here. So I'm in a helpless
But you
position.
did a good job. You did the second marriage only for protection of the
Protection
That
of
is
Lord-
not correct, lordship, which she has stated. lordship.
children.
For which
For-
the
for
learned,
them only.
learned trial court, lordship, passed an order to recover the child because she will not care.
Recovery is not
Intention
the
was
thing,
good.
Lordship, because
Only for their better future only he got married.
And now they are.
betterment of future of these
their own
children.
mother, lord.
3 children, Lordship, she eloped with a driver. And now my learned brother said that she
Later-
as a second marriage. I'm in a helpless position being a husband.
Anyway, okay.
And I have a moral duty.
Moral duty, obviously. Heard Mr. A. Sharma.
Already on that allegation, everything was there.
So heard Mr. K. K. Prasad, Learned Editions VP, appearing on behalf of State Government. And Mr. K. A. Majumdar, the council appearing for the respondents. From the office note dated 12/2020, it is seen that the scan TCR is awaited. In the office, the raised by directed issue reminder for instance, this scan TCR along with the KZR if any related, along with the KZR if list the matter accordingly until 24th July. 24th of July will
24th of July, Lordship. 24th July. huh?
It may be on lordship 28 July, it will possible.
20th July, Lordship.
It may be-
28.
28.
28.
No.
Obliged, Lordship.
March of lordship.
Yes, sir. No. Yes, sir. What about those cases? Ibahin. Atir Prakanti is a mamaki. Connected so.
Both.
What to say, Mr.
Ajay
Chaudhary has been engaged in other sports, I think. Now,
Lordship?
Mr. RKD Chaudhary, he has been engaged.
Yeah, in fact, Mr. K.N. Chaudhary and RKD Chaudhary are both arguing in code number 7. Both are in the same thing. I was just watching the video. So if you give me just 2 minutes, I think they are over with it. If matters are over.
I'm just rising now.
Oh,
I'll
right.
give you anything.
Then Lordship may fix it on Monday. Because it's a very small matter.
Next week is not at all possible. Monday kiva ase jani scope. The scope is not there because it will be declared as a motion week and that many matters are there on Monday also. If somehow can be. But you are saying Monday, whether what is the position?
Yes,
of the other side?
both I have conquered because I have asked Mr. Akedi Chaudhary as well as Mr. Kane. Monday, because it's a very, it's just limited because the decide and the order and the judgment is already there of so
Okay,
it can be passed. It is just a two pay line order. It will be
Okay, then, okay.
Monday.
We'll listing it on Monday.
Deeply obliged.
22nd. Request for 20. 22nd of this month, we are listing.
20.
Yes, it is an IA,
Yes, madam.
AB.
I wanted to inform that, my lord, after getting the interim order, the petitioner, my lord, went there. Then the IO state comes later, my lord. When the next time he has gone, IO said the charge should file. So I couldn't appear, my lord, the charge should.
Just tell us one thing. Have you furnished the order of
Yes.
the interim?
Yes.
That is, they have accepted?
No, they have taken it, but they did not take any my statement, my.
Then
Just submitted, my lord, and he said he'll come later on. We have taken my details in my.
So what is your prayer now here?
Now, prayer, madam, only that thing is to be informed before lordship, madam, because your lordship directed to appear within 7 days. So I have gone there, but I could not in the meantime charge sheet file. So that may be put on record, and your lordship may renew the order, madam. I am ready to appear, madam, in the court.
Now, consider that your appearance before I is not required.
No, that I understand, my lord, your lordship that here. Now, only question with that part, my lord, because I brought your lordship to the notice, my lord. I have gone there with certificate copy. And date also given when I have gone there.
When your AB was fixed, on when which date?
Or AB was fixed?
AB is fixed today, my lord.
No, that by order we have got.
Yeah,
By order, because affidavit is filed by order. AB copy fixed as in?
16/6 today.
Oh, 16/6. Oh, today, madam.
16/6, that means today.
Yes. That is, AB also fixed today, madam. Charge sheet now, charge sheet file. To our information, whether they got information, I don't know.
We don't have any information.
But they have stated we did not get any copy of the charge sheet, madam. Let them get the information with the charge sheet file.
But as per, do you have any information?
Malat, no, Malat, because Malat, I think it's an extension of time only, Malat, we have not checked Malat, and it's in orders, Malat, not in bail hearing. And our office staff also didn't provide
Then do
any information regarding the CD.
We'll do one thing. Let their I be trained and recorded, because at present, though they have some information, but we don't have any information regarding the filing of the charge. So let the I be disposed of with a extension of interim. In that event, if we recover the charge sheet, then only we'll record the other submission.
Then that will also pass regular.
Not have anything for us. Whether charge sheet is filed or not, that is also not.
Well, that will come from their official
note and.
Yes, madam. Your lordship, absolutely right. Absolutely right.
Mr. H.R. Chaudhary, the learned senior counsel, assisted by
AF and Mulla. AF and Mulla. Afnu Mulla.
And you also had Mr. K.K. Prasad, the learned SLPP, an application. This interim interlocutory application has been filed. Yes. But your application is not for any extension, na?
No, that I just.
Prayer is not there.
Yes, madam. I someday put before your lordship information to be your lordship. What happened to? Because in terms of your lordship, we have gone there. And I can.
Interlocutory application has been filed for praying for necessary order. Necessary order. In respect of the interim order granted to the petitioner dated 25/5/2026 in AB number 1064 of 2026. It is submitted by Mr. Chaudhary, the London Senior Counsel, that in person to the order of the interim in person to the interim order, the petitioners have appeared before the IO, but they were asked to appear on the next day. But on subsequent day, it was informed that case has already been charge sheeted, though they have not provided with any copy of the charge sheet or any charge sheet number. Mr. Dixpara, Mr. Parashar, the learned additional PP submitted that they do not have any information in regards to filing of the charge sheet in the present case. Considering this submission made by learned counsel for both sides, it is felt necessary for extending the interim protection provided to the petitioners by order dated 25/05/2026 till next date of listing. In the meantime, the petitioners are at liberty to appear before the IO if the charges is not late, if the charges is not yet submitted. With the above observation, the present highest stands disposed of or AB to Taha, hard so and so prohibitable in view of order passed in IA Criminal 608 of 2026. The order of interim protection dated 25/05/2026 is hereby extended till next date of listing. Also call for the case diary or the report from the IA. We are calling for the case diary report from the IA. We don't know what is their case.
17 July.
17. 17 of this month, next month. 17. How much? Hearing the, I think only bail matter, one bail matter was there, that much only. Thereafter, other matter, remaining matter was left and I took.
16.
So in that case, I assure that you don't want to worry about that. 2 p.m. means 2 p.m. will be taken.
That's fine.
And for you also it will be taken.
All right. All right.
The paucity of time for 14th.
So 16 July
16 July at 2.
at 2 p.m.
Proxy may take up this matter after vacation, my lord, because it will take some time, my lord.
Yeah, obviously, after vacation.
And my lord, moreover, civil suit is pending.
Pardon?
Moreover, civil suit is pending in this case, my lord.
Is there any date for?
My lord,
civil case now?
there is a stay operating in this
Yes.
matter.
We are having a stay.
In the entire proceeding, my lord. That's why, my lord, if I have a similar prayer, any date at 2 p.m. if it can be taken up, because several instances, any date, my lord.
21st of July after vacation.
At 2 p.m., my lord.
At 2
2 p.m. is
cannot
not
be at
possible,
this
my
time.
lord. Even we have
Stays
many
cannot be
matters.
2 p.m.
Normally
I
it will
can
come.
understand the stay is operating, but still it is a 24 matter at 2 p.m. cannot be taken up.
Right.
We'll try our best, or you make a mention in the
My
morning
lord,
hours also on 21st of July.
I'll do that.
21st.
Interim was there, na?
Yes, there is an interim order.
Interim be continued till next. It happens, I know, if once
I
interim
understand,
is
Lord.
there, then interim is there, then if they are enjoying the interim, Mr. Bora
Yes,
is
ma'am.
enjoying the interim.
Lordship is also tired. The entire day hearing is
Now if you go to my chamber, you will see
Yes,
my lord.
piling up like this. Have to walk for 7:30.
Yes.